I have come up in view of the fact that there is a finding to the effect that a DA getting school is amenable to writ jurisdiction. Now there are many other teachers.
That point in your opposition, Mr. Chaudhary. We
Milord,
will record that.
no, but kindly, only keeps this point of maintainability open. It has been decided against me.
Which portion?
Milord,
Which paragraph?
kindly sees page 217.
217.
My lord. Lord, that would be in volume 2.
So, Mr. Chaturvedi, they will not oppose you from taking that stand in your opposition. Anyway, what is the observation of the court?
Yes.
Page 213.
17. It starts 217. Lord, kindly sees page 218, paragraph 6. And in the previous round of litigation, this issue intersect the same parties between the school and this teacher is pending. The court has said that
what is pending?
That this teacher has filed a previous writ petition where the school has raised the issue of maintainability. That point, is still pending, adjudication.
The previous writ petition was filed for what?
For release of salaries. For release of salaries.
For the period?
For an anterior period, For an
so that is pending.
That is pending.
Appeal is pending.
No, writ petition is pending. The learned single judge, has said that he,
paragraph 6.
Yes. Insofar as this is concerned, paragraph 6.
That is your submission.
Yes. Then, kindly sees paragraph 8. Court at this stage is considering. Then, kindly sees paragraph 9. This is, what is really affecting me. Therefore, the said school ought not to be termed as unaided institution. Why, because it is receiving DA. This issue, is decided by the Honorable Supreme Court in Trikun Chandra, has been affirmed in St. Mary's. And then, kindly sees the next page. The same page, paragraph 11. Taking note of the judgments of Honorable Supreme Court reported in so-and-so, and another judgment of the Honorable Supreme Court in so-and-so, it was held that writ petition against a DA getting school is maintainable. Therefore, preliminary point which is urged on behalf of the said school is negated relying upon. So this point is decided. A school is in some financial doldrums. There are many other teething issues for which time and again the management will have to contest proceedings before this honorable court. Until unless this finding is stayed, I fully bow down that during the pendency of the writ petition there cannot be any recovery of whatever the management is claiming. But kindly stay this portion of the order.
No, there is another judgment, Mr. Chaturvedi.
After St. Mary's?
Marwari Balika
Vidyalaya.
Yes.
Marwari Balika
Just
Vidyalaya.
no. Marwari Balika Vidyalaya is
Before
Army Welfare 2024. 2024, which in paragraph 42, it affirms the findings of St. Mary, says that there must be a public law element. Now, my lord knows, in view of the 8th March 2018 amendment.
Now, where is that order inter se the parties? Another writ petition?
Yes.
That you have not annexed?
No.
Then what is page 229?
The 229 is a judgment passed by the learned single judge in another writ petition, which was appealed against.
Why should I happen to some of this?
What is your stand? If we keep the point, because maintainability point has been decided.
My only request before your lordship, kindly decide the maintainability issue. If that issue decided in my favor, then the writ petition is entitled to be uh, allowed. This is the only small issue. Your lordship kindly decide.
It will
please.
take time, no?
Yes, yes.
My lord, I'll
It will
take, my lord,
time. Kindly fix any day subject to your lordship convenience.
Maintainable বলেছো?
my lord, I'll take, my lord, 15 minutes.
सेम्स मेरी सोसाइटी इसके अर्स में
বলেছো not
এখানে
maintainable.
পিনাকি দ্বারা
But my brother's point is that yes, assuming you are public, but but the contract which you have entered into with your staff, that cannot be come within the ambit of this. That is a private contract. So these two issues are bound together. In fact, recognition is bound to the issue as to whether they could have terminated without following one A, B, C, D, E.
Yes.
Yes. Go through it, Mr. Chaturvedi, and come back.
I also I don't know whether such example was given. A nursing home is duty bound to follow clinical established rule and other rules. But a nursing home, when entering into a contract with a staff, that is totally private. But a nursing home, private nursing home, but he is bound to follow clinical establishment act such and such. But since he is following this act, that means he will be public body, not that.
But that is the precise finding in paragraph 68 of St. Mary's.
No, employment in private sector is a matter of contract, but employment is government sector is a matter of status. So there is some
Alright, you
difference.
go through it,
My
tell
bad,
us when that একটা দিন রেখে দাও।
My lord, Monday.
Next week we have packed matters. There is no urgency as such.
My lord,
No, urgency is my lord. My client is not getting anything, my lord.
urgency is, as I said, my lord, that in the meantime, my lord, I may face, my lord, writ petitions. It may
We
be
can open the, we can
the issue of maintainability, my lord, let that be stayed, my lord, and kindly fix that.
decide it.
করে দিয়েছে।
Hold for this, সেটা আমাদের ইয়ে করতে হবে। এটা তো open to be decided at the time of final hearing.
তোমার কত হোল্ড করেছে ডিসকাসিং সুপ্রিম কোর্ট। তোমাকে এই
Maintainability, my lord, which is
No, no, no.
we will decide on that. Point of maintainability we will decide upon going through the judgment. We will
Right.
allow you to urge on that issue.
in the meantime, let it be stayed. That is my plea.
There is for what?
Not the issue of maintainability, my lord,
No.
which has gone against me.
Yes.
That finding, let it be stayed, my lord, or
We
else
will decide that point because Justice Bhattacharjee has returned a final finding that it is not maintainable, which you are saying you keep it open at the time of final hearing. We cannot cross that hurdle. Na? We have to overcome the rigors of the direction given. For that, Priya Chatterjee, Marwari School, etc. Moreover, this judgment I was not aware of because this is a very recent order which
yes,
my brother has.
even I was not. I am extremely grateful that my
So
lord.
you check it up, we keep it on 2nd December and decide if it is maintainable. We will send you to do write in the writ petition.
Grateful, my
তুমি 1 তারিখে ফিরছো 1 তারিখে ফিরবে
In course of hearing,
ঠিক
in
আছে।
course
Item number 10. At item 10, I appear for the
And IEP for the University of Calcutta.
But compassionate appointment. Compassionate appointment.
No, my lord.
this is regarding selection for the post of professor. Post of professor.
Section 5 to target din allow করে দিয়েছে।
Section 5 has been allowed, but on the
I
9th of
appear for the, I represent this.
For the, yes, Mr. Babu.
No, this is essentially a hearing matter, my lord. Can we come back any day subject to my lord's leave, my lord? আজকে
What,
hearing করবে?
writ petition was preferred challenging what?
My lord, there was a advertisement for the post of professor SC category under the Department of Southeast and Southern Asian Studies, University of Calcutta.
Oh, so
My lord, he
prayer for-
participated.
his prayer for appointment has
Right,
been
right.
rejected.
My lord, he participated therein, and my lord, nothing thereafter happened. So he had come with the writ petition saying that in spite of my participation, you did not declare the results, and I should be appointed. My lord, on the very first occasion, the Honorable First Court, my lord, directed the university to file the status report and in a sealed envelope, my lord, we placed it before the court. That wherefrom it reflected that the selection committee considered the candidature of the petitioner along with other participants and found that petitioner has scored 29 marks out of 100 in the selection process. But the selection committee found none to be suitable and the selection process was abandoned.
Challenging that.
My lord,
yes.
that none found suitable was not under his challenge, not even challenged in the writ petition. My lord, he has come to the court saying this.
What was his prayer in the writ?
My lord will kindly take the prayers, page 77 of my lord's.
But when he
stay.
filed the petition on an allegation, result has not been
Absolutely,
published.
I'm grateful.
So when the result was placed before the court,
I'm
it was
grateful.
very disappointing.
It was found that the selection committee found, my lord, none to be suitable. Page 78 is the prayers in the writ petition. I will kindly take the prayers.
7 onwards.
Now, have you taken steps for fresh advertisement?
Well, we will be. But I'll take your lordship to one more document on page 221, my lord, whereby, my lord, it was the records were placed before the court. The document, my lord, which goes to show page 221, my lord.
Is there any contemplation that you would be filling up the post?
My lord, it might be. My lord, not immediately, not within 30 days or so. But my lord, your lordship will appreciate that this writ petition was in 2020.
Mr. Chatterjee, then prima facie, upon hearing you, as the appeal is before us, then he will pray for an interim order not to
Since
fill up.
2023, in the writ petition, he has failed to obtain any interim order.
Right.
So, my lord,
If the post is filled up, appeal becomes infructuous. No?
then your lordship is finally hear out the matter next week anytime. Your lordship pleases.
My lord, after participation, my lord, this process cannot be questioned. That is certain. Lord, your lordship knows better
Yes,
than
yes.
I do. So,
Then we can start on merit today.
The difficulty is, my lord, we have placed a
Your
extensive.
status report is here.
Everything is here. Everything is here. Only thing, my lord, allow me to come back with a note. My lord, the note will assist the court. Allow me to assist the court by virtue of a note, my lord, today which I have not prepared with. My lord, we have assisted the honorable single judge with a note, which, my lord, had everything. The UGC guidelines have to be, my lord, placed before lordship. Everything. My lord, allow us to come back.
Give a copy of that note to Mr. Bhattacharya.
We have shared, already shared. In the
Shared.
writ court, we have shared. Yeah, I can also give him, my lord, another copy.
we were not there in the writ court. A different set of advocates were there. We take a change and we have filed the
So
appeal.
Mr. Chatterjee will give you a
Certainly,
The
certainly.
entire record of the first court is annexed.
In that, the report is there.
No, it's a note, my lord,
That
not
is
report.
content.
Our report is there.
Mr. Chatterjee, you take,
My
you
lord,
say,
my
let us,
lord, my lord.
if it comes to any
My lord,
query
my
from
lord,
it, yes, you place.
That the affidavit in opposition, the affidavit in reply, all are.
Yes, place the judgment.
That may I say, your lordship, the short fact, then I'll come to the judgment.
Hearing এ যেতে হবে।
It's a very longish judgment. And shall I place the fact in a nutshell, or the judgment straight
They're
away?
thinking as to whether we will take it up.
But the role of the government is very, my lord,
Very
feeble. One, my learned junior is, your lordship promise me, my lord, I can
Yes, yes, yes.
trust
Yeah.
you kindly, my lord. I'm grateful, ma'am.
Final শুনুন।
Selection process after
And but
either
it
in
was
the
not
advertisement
advertised
or
at all.
anywhere. So after completion of selection process, they cannot say that since you have secured such and such marks, you are
Yes.
not be suitable. It is your case.
Absolutely.
And whether, and he will show any UGC guideline or
I will
anything.
show page 221 just now, Malad, what Mr. Chatterjee has placed before your lordship. Malad, the very interesting part. There is only one post for SC, scheduled caste, for the post of professor. My lord, it comes to 221 page. Only 2 candidates were there. Serial number 2 and serial number 5. Pankaj Kumar Mondol and me, Topon Kumar Das. But I got 29.74 and Pankaj Kumar Mondol got 23.12. I got it?
Coach Kumar Mondol and
2, serial 215.
Topon.
SC. The post is meant for SC.
You got 29.7.
I got 29.74. 5.
Now, what was left out according to you in the advertisement?
Well, at the cutoff marks. This is number 1. Why they have declined to grant me
Now,
appointment?
let us understand, if there had been no cutoff, they have proceeded on the basis that there was no cutoff. So if there is no cutoff, you have secured lesser marks than the other candidate.
No. Only 2 candidates, 2 and 5. 2 got 23%.
Then 23.2 and 29.74.
I got 30.
So specification of cutoff, how could have helped you?
But I tell you, lordship.
Suppose if the cutoff was 30, then you would have been outright rejected.
How?
So that does not cause you any prejudice. The specification of cutoff, subject to what you say, is not prejudicial to you. Now, what is your next point?
But I have 2-3 points.
The demo test. There was a requirement of any demonstration.
Malad, I tell you, lordship, Malad, in the advertisement, Malad, there is no such provision on the strength of which, if I get Malad 30% marks, I will be Malad rejected or my candidature will be rejected. There is no such provision. But I stick to the advertisement first. Second is,
Was the advertisement?
yes. Malad, your lordship, straightway turns to page 82, the advertisement. The relevant part is 85. The advertisement was dated 17th of February 2019.
Yeah, just.
85. এটা পুরো এতে বেরিয়ে গেছে কনফিগারেশন আছে পরিষ্কার
হ্যাঁ
আচ্ছা I'm contesting for serial number 13, page 85.
Yeah.
Gotcha.
Page 85.
Yes. South and Southeast Asian Studies. Professor, one is general, one is
Yes, 85.
yes. Now, serial number 13, for which post I am contesting. South and Southeast Asian Studies, Professor, SC1, one vacancy. Now, your lordship can consider the qualification and experience.
They are associate professor. You
No.
are
Associate আছে
Associate, I'm contesting for professor.
one
Third.
3. Professor
then-
is
13 you are showing.
yes, 13. 2 assistant professor, then professor 2.
Acha,
One
you
is general.
appeared for professor. All right. Then what you
One
are-
is general and one is SC. I'm contesting for SC. Now, your lordship kindly sees the result once, page 221. Your lordship
that
will
was
find.
given after read petition was filed.
Yes, yes, yes.
2 to 1. Yes.
Result was never published. But at 2 to 1, your lordship will find that out of 2 candidates, there were 2 contesting candidates.
There
There
were
are 2 contesting candidates, serial number
2 SC.
Yes, 2 SC.
Hmm.
Serial number 2 and serial number 5.
Hmm.
But I am the topper. I got 30% marks.
Where from you're getting this 30% right?
The 29.74 comes to 30.
30% cutoff was not there.
30 out of total 100, I got 30. So, I got 30% of the.
So as there was no cutoff, you are entitled to be appointed. This is one point.
This is one.
Acha, what is the other
Second point, if your lordship kindly sees, Babu.
So that there was no cutoff is an admitted issue.
No, cutoff was not there.
No, they are opposing that. They are
Yes,
saying
yes,
there
yes,
is a
yes,
cutoff.
But what they have said, the stand they have taken in the affidavit in opposition,
Hmm.
it is very important. Kindly turns to page 180.
180.
Yes.
Yes.
C. That the writ petitioner has scored 30% in academic performance, so and so out of 100. This score is given by the selection committee on the basis of the candidate so and so, as set out by the so and so. So,
Yes.
now your lordship kindly turns to page 178. A.
No. Where is the defense as regards cutoff?
But there is no cutoff. Kindly see why they have denied me. Page 178. A. Serial A.
178.
8. A and B.
No, this none is suitable. Was this a order of the where anywhere in the status report which he produced? Not suitable was written anywhere.
This was what was produced. Page 221, my lord, kindly take.
We will come to you. Just let us understand.
Now, this is the affidavit in opposition for the first time we have come
Please
to.
place now which paragraph you have.
Page 178.
To
paragraph
read it.
A.
Which
Yes, it will settle proposition of law that mere participation in the selection process does not create a right in favor of the incumbent, as in the instant case the selection committee, a specialized body, found none to be suitable, including the writ petitioner for the post of professor under the scheduled caste category in the department of so and so. Under such circumstances, the petitioner did not derive any right to be selected in the concerned post.
so
Then
this is participation not suitable, so we did
next,
not.
the selection committee found non-suitable under the scheduled caste category for
Same,
the post.
same thing.
Same. Number under which law? But how they have come to this finding that we are not suitable?
Very good. To that, you must have raised that point.
But I have raised that point in a affidavit in reply. Kindly
Very
have-
good. Now, what was their stand in the status report? Their any answer they gave?
Status report I don't have because we were not the advocates before the first court. But the affidavit, opposition, and reply all are complete. Judgment has been
Your ground in the writ petition was no cutoff was specified. As a consequence thereof, you went to the writ petition at this
on
stage.
2 counts. First is result was not published. Second is give me appointment. That is my prayer. PRIYANKA petition of PRIYANKA.
Page 77.
Page 77. Page 78. Affidavit once for it. Page 180 onwards.
Not onwards. Tell us the portion.
Lots. I'm coming. 181. How I have performed.
No. Where is this University Grant Regulation of 11 July 2016?
That I will come. I will come to your lordship. How the marks have been granted. But kindly have a look to 181 once.
181.
Yes. D. First paragraph. On the basis of the above mentioned performance, the writ petitioner has scored total so and so in the selection committee assessment on so and so. Then, and no one was found suitable under the scheduled caste category during the selection held on 6 February 2020 for the post of professor under so and so.
Where did you show that this 20 marks for academic records? Where is this distribution in the advertisement? It was given this distribution of marks.
Let I tell your lordship, page 221. Kindly have a look.
Very good. Now this distribution was referred to that you will be marked in this fashion in the advertisement.
Advertisement is page 85.
This breakup of marks, Mr. Bhattacharya.
No, not there. Not there.
You just now showed. Where did we find? Just now you showed, na? I have seen this.
Breakup of marks.
The advertisement said UGC regulations will be followed. UGC prescribes the distribution.
No, which
195 or anything here. 50, 30, 20. 50 academic, 20 domain knowledge. It is 180, page 180 they have pleaded, and 195 most probably.
180 they have pleaded. This code is given by on the basis of academics background
and 200.
Research program and publication, assessment of domain and interview performance. Very good.
200 most probably the relevant circular or anything of the guidelines of the
11 July.
Memorandum. That means 200. 200. Academic record and research performance 50%.
200.
Assessment of domain knowledge and teaching skill 30% and interview 20%. Total 100 out of 100 marks.
Yes.
50, 30, 20.
Advertisement that is page 207, appendix
200 confirm? 200 this table. Okay. Professor. Professor. Committee, marks.
Then 208.
এইখানটা schedule কোথায় থাকছে? Distribution of weightage marks in expert assessment. এই যে 50-20-20 যেটা ওরা এভিডেভিডে 181 বলেছে,
হ্যাঁ জানি,
সেটা
200.
এখানে কোথায় গাইডলাইন?
এটা হচ্ছে প্রফেসর বললো তো 200
But in page
ইয়ে হচ্ছে
200, right? Proportion,
Professor
professor stage 5. I'm competing for professor.
প্রফেসর হচ্ছে 196
প্রফেসর স্টেজ 5,
Yes. Page 200, last column, right hand side, last column.
196 থেকে দেখলাম প্রফেসর, তারপর পরবর্তী ক্ষেত্রে এইগুলো সব চলছে, এলিজিবিলিটি ক্রাইটেরিয়া হলো তা
Yes.
মার্কসটা
196 professor.
হ্যাঁ মার্কস
this distribution of marks where it is given.
Well, this distribution of marks, page 200.
Yes, which one?
এই যে এটা সেকেন্ড কলম
Professor
20,
stage
40,
5,
20.
consolidated API score requirement of 400 points. Then academic background 20.
From categories Roman to Roman 3 of APIs. API is what? What is API?
API.
Pure আসতে
it would be last column.
Annual
Consolidated
performance.
API score requirement of just 400 points.
Academic performance indicator.
Academic.
API.
It would be column, last column.
Then
minimum, there has to be a minimum API score.
Yes.
Consolidated API score requirement of 400 marks points from categories Roman 2 and Roman 3 of APIs. What is this?
They can
Next is academic
Yes.
background 20, research 40,
40.
and assessment
Domain
knowledge
knowledge
20. On this
Interview
basis, they have gone.
They have shortlisted.
So there is no provision for cutoff in the regulations also?
Now, my lord, your lordship can tally page 200 to 221. My lord will get the entire picture. 200 and 221.
Yeah, that is they have stated.
Yes.
That academic
Academic
record,
score, I have scored 13.
then what they have stated, anyone stated in the opposition as regards cutoff?
Nothing.
Which paragraph in your read petition you have taken that point?
But in the writ petition, this point
Oh, that was not
no,
there,
not
right.
that. The result was not published. In the reply, my lord, I have taken this point.
I see. Where reply which page?
But your lordship kindly turns to the reply once. Page 235 onwards. 235. Well, at page 240, serial number Roman 12. No demo test was taken. Then
No, where?
page 240,
Huh?
Roman 12, last column.
I say as appears score sheet annex to the opposition at page 46. Which is that one? Score sheet annex, page 46.
Of the writ petition. But kindly skip that. Kindly skip that. Then your
No.
lordship
Page, this is score sheet they have referred to in page 181.
Mhm.
That is the marks you got.
That is the marks I got.
Page 181. There is a column where marks are allotted for demo and experience. Where is that document? Page 46 of your opposition.
Page
46 of the opposition.
page 46 comes to 221. Page 46 of the opposition comes to 221.
Yes, that is true. Very good.
It's the Lordship is will get
Where it is given demo in
Huh?
221. There is a column wherein marks are allotted for demo and experience.
It is there, my lord.
Huh?
It is there, my lord. Third, I will kindly take the third column
Category. Third is category. Page 221.
221.
Yes.
My lord, last is total. There-
Last is total. Yes.
Before that, interview and performance.
Right.
Before that, I will kindly see assessment of domain of knowledge
Huh.
and teaching skill within brackets demo and experience.
Demo stroke experience.
Madam.
Very good. So no demo test is compulsory, Mr. Bhatt.
that is not the case. Well,
Interview, you have got in that 3 marks.
Mhm.
Total was 10, the total was 20.
Mhm.
You have got 3 marks.
3 marks.
Now it is a demo stroke experience.
But if I skip that,
Very
that
good.
kindly turns to
So one round of your was no demo test.
no demo test.
First round was no cutoff.
Yes.
Second is no demo test.
No demo test.
This you could not take in the read petition because at that time there was no disclosure. Very good. Now
Then your Lordship kindly turns to page 241.
two 41.
Hmm.
Yes.
Roman 14. I say that candidate who was considered for appointment, being Achinto Kumar Dotto, was given 13 marks for the demo test, whereas in reality, such test did not take place at any point of time.
Achinto Kumar Dotto.
But Achinto Kumar Dotto is not a SC candidate. He's a general candidate. I'm not
Yeah.
concerned. But in case, in his case, demo was given.
Very good. This is your challenge.
This is my challenge. But
Now, how did the learned judge deal with your challenge about cutoff?
now your logically turns to the demo was not argued. Well, I was not there before the first court, but I cannot say that if your lordship takes up the judgment.
Judgment is at which
Yes, 27 onwards.
page 27.
Hmm.
Show us only that question. No? What reasoning was given?
Well, at page 41 onwards. Paragraph 16, page 42. Even otherwise, it would be an
Just. Conjoint reading of 6.2.0 and appendix 3. Please, paragraph 12 kindly come.
It's paragraph 12.
So, a conjoint reading of 6.2.0. That is at page 208. No, 200 থেকে আরম্ভ হচ্ছে 6.2.0. Where is 6.2.0 হলো তো? Professor. আরম্ভ হচ্ছে 198 থেকে. Which is this clause? Where is this clause 6.2.0? Did we table 2A? Appendix 3. Appendix table 2. Table 2. Bracketed Roman. Bracketed
196, the professor.
da.
এইখানটা যে যেটা বলেছি টেনে এই জায়গাটা দেখালি some conjoint reading of regulation and এই যে
সেটাই তো finding.
minimum score হচ্ছে for direct exam
For 50
out of
এই যে এটাই প্যারাগ্রাফ 12.
UGC regulation 2010.
This was the argument. Finding টা তুমি কোথায় পেলে? পেজ কোন পাতাটা পেলে?
এটা হচ্ছে internal page 10
না সেটা তো সাবমিশন দেখছো তুমি।
হ্যাঁ internal page 10 এইটা
That turns to paragraph
এটাই ও
16,
deal
one
করলো।
second, page 42. Even otherwise, it would be an
Just now.
appendix টা বার করতে হবে। Appendix 3, table
যে appendix লিখেছি
UGC regulation 2010.
3 table 22 of the regulation 4th amendment 2016 এইখানটা দেখিয়ে দিবি
এটাই তো খুঁজছি। 6.2.0 টা পাবো কোথায়?
6.2.0 টা
পাচ্ছি না তো।
I have a copy. May I hand up here? I have one copy.
এরা switch paragraph আসলে?
But I cannot corroborate with the stay application. This is within the notes that I had filed, and I wanted to assist your lordship on the next occasion also. In the note, my lord, I had.
regulation 6.2.0
May I read it for your lordship?
UGC regulation 2010
May I read it for your lord?
and appendix 3
May I read?
UGC regulation 4th amendment
My
2000
lord, this was there in the notes that I have produced.
সেটা তো এটাই যেটা প্লেস করছে ও। এটা আবার কোথাও? This is which regulation? না ও বলছে
UGC regulation
ও
দেখুন।
বললো 6.
This is of 2010.
This is not
আগেরটা দে।
I was just
এটা বলো 07.
will to see provides norms for direct will to and table to will provide cash promotion. So the appendix 3 Roman appendix 3 table 11A.
appendix 3 table 11A of
207.
11A is, my lord,
Here it is.
207
Yes.
the UGC regulation 4th
Yes,
amendment
yes, yes.
2016
Appendix 3, table 2A, which my lord has, Justice Sengupta has mentioned.
207.
Where is that? 207.
Yes.
It's not telling.
Yes. Appendix 3, table 2A. তাই তো বলেছি তো স্যার। Yes.
Table 3, table 2A, where do I find? That all
207.
table
Bottom part. Here.
bottom part.
Yes. Here.
Table 2, yes.
And Justice Sengupta has specifically mentioned in paragraph 11. UGC regulation 2010 and appendix 3,
Where?
table 2A.
Very good. Where is that provision in the table 2A?
দিয়ে দিন আমায়।
এখানে কি table 2A আছে?
Everything is there, my lord.
Table 2A আছে এখানে। ওই যে এটা দেখাচ্ছে। এখানে তো কোথাও নেই। Table 2A is for direct recruitment.
This is a case of direct recruitment.
Right. But Mr. Chatterjee, where do we find that?
Well, kindly give me a back. I'll just hand up, my lord. I'm so sorry, my lord. I should have come with 2 copies, my lord.
Now show us table 2A, which provision you are placing reliance?
May I say this, my lord? How, my lord, the approach is, my lord, the advertisement said the government notification date and UG of cadres either through direct recruit promotional. Now, the direct recruitment notification does not specify the cutout mark. But this career advancement scheme regulations specifies that minimum 50% has to be there.
Why you are showing that? However, read from however.
However, since teachers recruited directly can be from different backgrounds institution, table 2C
Huh.
of appendix 3
Huh.
provides norms for direct recruitment of teachers to
So
different
it is appendix 3, table 2, table 2C. Table Roman 2C is applicable in respect of direct recruitment of teachers.
manner.
Now, table 2C of appendix 3.
It is not there.
205, what is 205? Category 2,
Table
professional development, co-curricular, 20.
Where is table 2A?
My Lord Justice Chakraborty, kindly do not see that because this is 2016. He is referring 2010. I have given copy.
Yes,
This
where
is
is
2000.
table 2, where is the table 2?
My Lord,
Again, Miller.
two copies I have given to two honorable judges. I have only 2 copies.
Where is appendix 3? Where is table 2C of appendix 3?
আমার একটা কপি দিন, ওই কপিটা আমায় দিন।
এটা দাও।
জজ সাহেবকে একটা copy দিন।
6.2.0 deals with direct as well as cash.
Right.
However, in respect of direct, you have to follow table 2A appendix 3.
Page 207.
But that is Mr. Chatterjee 2016 regulation.
So, Milord, it says, Milord, the 2016 regulation is also to be followed
Where it is said?
in the advertisement itself, Milord. In the advertisement, it's spelled out that 2010 and 16 will be the governing, Milord, UGC notifications, regulations. 10 does.
Where is there? In the advertisement, page 82?
Kindly
Page
allow me to come back with the notes, Milord. This will immensely, Milord, help me to assist your Lordship. Tomorrow I can come back, Milord. This will be required, Milord. And your Lordship can hear out the matter. I don't stand in the way, Milord.
Table 2A is professor, na? But stage 5 দিচ্ছে আমি বুঝতে পারছি না। টেবিল 2A এইটা যদি দেখো ওর position হচ্ছে
Page 85, my lord, will find that.
either direct or KD. Minimum API, minimum norms for selection. And API বলছে না, minimum norms of selection. এবার বলছে however since teachers can be from different backgrounds, table 2C of appendix 3 will provide the norms of direct. Table 2A and table 2B is for cash. তাহলে table 2A তে এটা হচ্ছে table 2A, সেখানে page 80 you are saying
85 it is said mentioned that Milord, higher education's notification UGC 10 and 16 will be followed. Page 85, my lord, kindly find it.
And 2016
16 আচ্ছা ঠিক আছে। এবার table 2A,
And kindly come to table 2A.
yes, that is
What's the page?
table 2A of which regulation?
2016.
Which you just now
My lord. Table 2A কোথায় গেল আবার হারিয়ে গেল?
108, your compilation, Mr. Bhattacharya.
Just a
wait, ও দেখাচ্ছে
You can take, we can see.
Well, kindly keep it with that.
table 2A is at page 207.
207. I'll show right away. I'm grateful, my lord. 207.
Bottom.
মাঠটা কেটেই গেছে।
You are for professor of which stage? 5 stage.
Professor stage 5.
Yes, for us.
Table 2A, your lordship has got. Finally, kindly come to page 208. And will kindly take the 5th column.
Percentage distribution.
Right. clause 5. Now, my lord will extreme right, my lord will cease. This, my lord, is stated extreme second last is professor equivalent to stage 5. Lordship has found
Professor, yes.
second last, my lord.
Uh,
Now, my lord, in the row of clause 5, percentage distribution of weightage points in expert assessment, weightage 100, distribution is stated.
50, 30, 20.
Right.
That is true.
Right.
That is what you have stated in your opposition.
Right, man. Right, man. এখানে ওটা কথা বলেছে আমাদের যে 50% মিনিমাম থাকতে হবে সেটা হচ্ছে কোন জায়গাটা আছে তাহলে
50% হবে research contribution.
minimum my lord, kindly take this note of this percent clause 5, my lord, page 208. Please, page 208, my lord, clause 5.
Yes. Page 208
Eight.
clause 5.
Clause
Yes,
5.
yes.
My lord, it says percentage distribution of weightage points in expert assessment, total weightage equal 100. Minimum required for promotion is 50.
That is for promotion.
Promotion. Now, my lord, 6.2, my lord, of 2010, I just read before some time, which says for promotion and for direct recruitment, the parameters will be similar. I'll take your lordship to 6.2 again.
No.
Yes, my lord.
6.2 says,
My lord, kindly come to 6.2 once again.
however, would it appear right at the exit?
6.2 টা কোথায় আছে? নোটিস বাচ্চাটা কেন হয়ে গেছিল তুমি?
Minimum section as well as APIs
the structure-টা কেন পাল্টে গেছে? এটা যেরকম ভাবে ছিল এরকম ভাবে করলে পেজ মার্কিং করলে না, কিছু করলে না।
Table 2C, Appendix 3 provides for direct recruitment of teachers to different categories, while 2A and 2B for cash. তাহলে টেবিল 2A যেটা দেখাচ্ছে সেটা হচ্ছে পেজ 208। এখানে বলছে 208 টায় আসো, দেখো। হ্যাঁ এটা দেখো, নো সেপারেট পয়েন্টস। আমার এই যে পেনাল্টি মেথড 50% হচ্ছে ফর রিসার্চ কন্ট্রিবিউশন, 20% হচ্ছে অ্যাসেসমেন্ট ডোমেন, 20% হচ্ছে ইন্টারভিউ পারফরম্যান্স। এবার কাম টু পেজ 181। ওরা তাহলে 20 মার্কস ফর একাডেমিক রেকর্ডস করেছে,
সুন্দর আছে
40 মার্কস ইন রিসার্চ পারফরম্যান্স করেছে, 20 মার্কস ইন ডোমেন নলেজ করেছে।
ওরা এইটাই ইয়ে করেছে,
এই নোটসে এই পাতাটা বাদ করো।
করেছে সেটা হচ্ছে ওই যে যখন বার করেছিলাম, হ্যাঁ তখন সেটা বার করলাম।
এই তিনটে কত জায়গায় আছে মাথা করো,
200 পাতা,
এটা হলো
পাতাতে ওরা এটা করছে।
মানে এইটা তো অ্যাপ্লাই করে না, কিন্তু অ্যাপ্লাই করে না।
ওটা খুলে এটা পুরো থাক এইটা ওই এই দুটো রেগুলেশন কে
অ্যাপেন্ডিক্স 3 এর টেবিল
এখানে রিলেভেন্ট আছে
অ্যাপ্লাই করে। This is for academic performance indicator.
Appendix 3, Table 2B.
এটা তো অ্যাপ্লাই করে না। That is for quantification of consolidated academic performance indicator.
ঘুরে আসো।
Page 208,
মালা
which you showed us,
Mala.
50% research,
মালা
30% assessment,
Mala.
and 20% interview. This is
Mala.
the distribution.
মালা মালা
Now, keep this open and come to page 181. Or the assessment sheet, 221.
221
academic records you have given 20 marks. But these academic records do not feature in table 2A. Table 2 যেটা বলছো that is for research contribution, assessment of domain knowledge and teaching practice and interview.
50.
These are the three heads.
Right.
So you have your three heads in which you have done is academic record and research degree, research performance. Then you have added one assessment of domain knowledge and interview. So 1, 2, 3, 4. That is not there in Roman 5.
হায়ার এডুকেশনে বলেছিল এই মার্কস ডিস্ট্রিবিউশনটা হায়ার এডুকেশন নোটিফিকেশন ছিল না নোটিফিকেশন আছে
API minimum score যেটা তুমি বললে 200 সেটা সিমিলার
Similar.
এবার 111 দিয়ে থেকে আসছে বলে ওই টেবিল কি ফলো হবে টেবিল অ্যাপেন্ডিক্স এবার এটা যদি রিড উইথ 50% এর জন্য দিয়েছ এবার 181টা দেখো ওই হেডে তো ওর 181টা দেখেছো হ্যাঁ এখানে দেখো তো
professor
কিংবা 221টা দেখো
this distribution was in terms of the higher education's notification which your lordship will find at page 111 my lord. It was said in the notification.
Mr. Chatterjee, why it will be so confusing? You are selecting a person from the advertisement, he will come to learn that what is my cutoff, what I have to secure. You are going in a roundabout manner because you have not specified. Now you are saying you kindly see government, UGC, etc.
That was prescribed in the advertisement. Advertisement, no doubt, could have been more clearer, more candid for the.
You have given rise to your own litigation.
I follow.
One line, sir, finished.
I follow. I follow, but nevertheless, my lord, it prescribed
100
that
page 100.
111, my lord. At 12, 112. 118, my lord. I'm so sorry, my lord. আমার লাইন ফাইন কেটে গেছে একটা ফ্রি পেজ মা করিয়ে দিও কোনো কিছুই বোঝা যাচ্ছে না
111
18 মিলট
118
18
yes what you that is table API. This is minimum academic performance indicator which should be same for both,
right?
Because 6.2.0 says minimum norm for selection committee as well as API shall be similar. So API is similar, there is no doubt. But marking is different.
No.
That is table 2A.
The second part of it, Manoj, kindly come to.
Yes.
Academics background 20, research. API, Milord, will come in the case of promotion. Here, Milord, we are concerned with direct recruitment.
So very good. Then
so, Malord, will kindly take the second part of it. Academics background 20, professor stage 5.
Where you are reading?
Page 118.
118 years.
Extreme right is professor. First is Milord, minimum API. This will come in case of promotion, not direct recruitment. For selection committees, Milord, is the second column. Extreme right, professor stage 5. Academic background 20. Research performance based on API score and quality of publications 40. Assessment of domain knowledge and technical skill 20, interview 20. This was followed. Now,
but where is the cutoff, Mr. Chatterjee?
No, Milord, it is like this, Milord. In the advertisement itself.
No, just interruption. Page 221, kindly come. This you have assessed him under 4 heads, which you showed in page 180.
My lord.
Page 221 have you?
My lord.
Now, that tallies. Academic records final is 20, academic is 20%. Research performance on API is 40, that is equivalent to 40%.
Malad.
And assessment of domain is 20, it is equivalent to 20.
Right.
Now interview is 20.
20.
You have followed this, but where is the cutoff?
Malad, kindly come to page 223. Will kindly turn the page 223. Where your lordship will 223, my lord.
Yes.
Where your lordship will find none found suitable by the selection committee. Your lordship has seen that.
So, Mr. Chatterjee, where is the cutoff?
Cut out, my lord, the advertisement prescribes that higher education's notification will be followed.
Accepted. But where is the cutoff?
My lord. My lord, it says, the advertisement says 2010 will be for UGC will be followed. The advertisement further says that 2016 UGC will be followed.
Right.
Now, my lord, the distribution of marks, higher education has prescribed. 2010 UGC has prescribed that for promotion and for direct recruitment.
Mr. Chatterjee, you are taking us through a diverted route. We have put one question. You are saying that a composite perusal of 6.2 and appendix Roman 3A will be applicable.
Absolutely.
So if that is applied, accepting what you have said, where is the cutoff at page 221? Tell us.
221. No, 221.
So no, I am saying this cutoff. If you are saying that you read all the three together, advertisement.
One has to,
2010, 2016.
Subject to correction from your lordship, by your lordship, my lord, one has to read all these three conjunctly, yes, in case of any doubts.
Tell us now that what will be the cut. Suppose there are 4 parts of selection.
50, my lord. In terms of this, my lord, will be 50. Page koto chilo ta?
Page?
Are 2A jeta chilo, seta koto? 208.
208. Yes. Where do you get 50?
Yes. Lord, this clause 5 your lordship has seen?
Yes.
Percentage distribution of weightage points in expert assessment, total weightage 100. Thereafter, my lord, minimum required for promotion is 50. And 6.2 of 2010 says promotion and direct recruitment will be the same. Your lordship will also.
But these heads, research contribution, assessment of domain knowledge, this does not tally with page 221.
My lord, there the higher education has prescribed. My lord,
where higher education?
Just now I showed your lordship, my lord, page 118. Well, my lord will also consider whether what right?
This is not a promotion, this is direct recruitment.
But 6.2.20 is showing, he said, the minimum norms of selection committee or selection procedure, as well as the API score requirement for the above cadres, either through direct recruitment or through career advancement.
I'm grateful.
Shall be
I'm grateful. I'm grateful.
Absolutely. That means API score would be similar.
Very good. Your API says assessment says 50% for research contribution, 30% for, that is the distribution of weightage. 50, 30, 20. It comes to 100. So there must have been a clause that 50% is for research. If you you have to secure 30%. Or in total, you could have said that 30% ought to have been the API.
It's not a question of 30 now, it's a 50, my lord. The UGC prescribes that for promotion, minimum 50 is required. And 6.2 prescribes that promotion and direct recruitment will be the same. So,
50% required where?
This, my lord, minimum required for promotion is 50. Again, clause.
Where page?
208.
Yes.
Clause 5. Percentage distribution of weightage points in expert assessment. Total weightage 100 marks. I'll stop here, my lord. Thereafter, my lord, minimum required
for promotion.
And my lord, 6.2 says promotion and direct recruitment will be the same.
That is not clear, Mr. Mukherjee.
My lord, I'll argue, my lord, that what right a mandamus cannot be issued. My lord,
How
asking,
did the court deal with that point?
my lord, we have placed the judgments of the Honorable Supreme Court, my lord, and
Don't fill up the post then, Mr.
we'll come back here. My lord will kindly appreciate, since 2003, there was no,
Chatterjee, you will not suffer an interim order.
my lord, like,
You are wanting to say, don't, I want to.
if someone has not enjoyed the interim order over a period of last 3 years,
Fill up
he
the
did
post.
not challenge non availing of any interim order.
Then
He
don't
he
fill up
did
the
not come
post.
to the court.
We are in ceasing of the matter, don't fill up the post.
May I very humbly pray this? My lord will kindly not pass any orders. Next week, my lord will hear of the matter. I will be.
That is our choice, Mr. Chatterjee,
Milord,
whether we will consider at
Did
the
I
interim stage.
did I even say, Milord? This is not. I said I started by saying, may I humbly pray for
But
this?
Mr. Bhattacharya, এতক্ষণ করে interim order.
One line order, but only one. This next week is very dicey. Your lordship knows that this next week proposition is very dicey. But when the next week will come, nobody knows. Many matters are fixed next week. When bench change, determination change, matters gone, never appeared.
Next week never come.
So, but one line interim protection.
Line for what? That we will hear it.
No, no.
কিসের জন্য?
হয়তো ও বলতে চাইছে
Not to fill up the
post
post.
can be that, but no post.
Or if you lordship kindly takes up the matter tomorrow,
I'll come tomorrow.
yes, finish it up.
Everything cannot be taken up tomorrow. We have taken 45 minutes time. And we are now saying we are not passing the interim order.
I have
No, my lord, my lord will kindly pass. My lord will kindly not take exception of my humble submissions, my lord. I have humbly submitted before your lordship. My lord will kindly not take exception. My lord will kindly pass interim orders.
I am for the appellant.
Lordship, in this matter, Ms. Pona Rao Chaudhary, appearing before state respondent, Lordship, praying for short pass over. She is in court number 2, Lordship.
What is the matter, Mr. Wadi?
Or I was
Any interim order requirement?
the final interim order.
Is there any scope of any interim order?
No, interim order, my lord, I'm not asking that it can be disposed of by your.
Yes. Oh, Mr.
No,
Judge
he has come.
Who is there? You are there?
Yes.
Yes.
Your lords is directed to take in instruction, state authorities to take in instruction in the last occasion.
Yes, Lordship. Instructions has been taken. Lordship, there is.
Get back your breath.
Lordship. Lordship, their main challenge is page number 53 of your Lordship's stay application.
Yeah, let us see the order.
Lordship.
Mr. Badi, you're returning April 2026.
Yes.
Yes.
They have taken.
Before that, my lord, the lordship knows that the pension papers are required to be submitted. Long before that. My lord, we have submitted everything. School submitted everything. Now, page 53 was the challenge before the trial court.
This is the usual quotation.
Yes,
No,
yes.
not usual.
There
Because
is
the
no determination that there is
no
any.
determination is not required because, my lord, the two additional increment which I have enjoyed in view of the, my lord, their own circulars. Now that circular says that should be, my lord, withdrawn. That circular, in which circular I was enjoying two additional increment, my lord, that circular was state authorities passed an order directing for withdrawal of that benefit. 2017. That circular was challenged before the coordinated bench as well as, my lord, the division bench approved the order of the coordinated single bench. That circular, particular circular was set aside. Page 2017.
Withdrawal certificate.
Yes, for which I was enjoyed. Now again, my lord, they said that this recorded separately HM fixation of serial number 29 and 35, which has been, in terms of that circular, may be rectified. And OD if arises, certainly it will arise.
935 is what?
Well, the serial number. Serial number 29 and 35 may be rectified if overdraw at all arises.
May be deposited through tier 7 challan. This is, my lord, the.
So these they have not taken.
No, the court said refixation, you do it, my lord. Let the patient die, thereafter I shall make a treatment. Your lordship kindly
You
have it.
created the problem. Why did you?
No, my lord, I have not created the problem.
Immature stage you have.
No, because of the fact, my lord, your lordship kindly see.
Respondents are directed to
Petitioner,
Well, we are in the verge of completion. We are in the verge of completion, my lord. The pay fixation is being done, your lordship, and it will be published soon.
Pay fixation has been done.
It is in the process because the court has said the pay fixation should be done at an early stage. So, my lord, we are in the
If the
process.
fixation is done at this stage, certainly, my lord, everything will go.
That is an anticipation.
Yes, your lordship.
My lord, your lordship kindly see the order passed by this court, page 59.
Directed to.
No, my lord, your lordship kindly allow me 1 minute time. Petitioner is an approved headmaster who will retire on 30th April 2026.
Then you bring the pay fixation when you are short.
My lord, it will take time. It will take time. At least, my lord, 3 weeks it will take.
We are keeping it after
Lordship,
3
lordship, lordship,
Come with
lordship,
the pay
lordship
fixation.
can.
We'll dispose of.
Very
If pay fixation goes against him,
Lordship.
we will give him liberty to
Lordship,
challenge.
only one indulgence. My lord, so far as the instruction side is, my lord, it won't be as, my lord, the circular by which, my lord, the withdrawal was there is already gone. So, my lord, we cannot actually take the benefit of that circular, because once there are 2 increments that have been derived by the petitioner,
Right.
we cannot curtail that in any way.
You cannot curtail. That is overdrawal.
Lordship.
His pension will be in lower scale.
yes.
Lordship. Lordship,
That is the problem.
my lord, we are in the verge of complying of the order passed by the Honorable Single Bench, your lordship, and we are doing the process.
3% additional increment.
Yes. That has been your
My lord,
lordship's process ever.
and my
That has been settled.
and the
That
client of
that
my
is
learned
happened.
senior friend, my lord, is anticipating, your lord.
No, question of
But
anticipation.
because, my lord, what is the matter of challenge, my lord? My lord, specifically the words may and if are used therein, which is a subject matter of challenge at page number 53.
No, madam, if
Lordship.
fixation, suppose you are saying 3 weeks, suppose it takes more time, then
Lordship.
the person's retirement is
I bow down to that. I bow down to that.
if you come within 3 weeks that this is the pay fixation,
Yes, your
which
lordship.
will be contrary to what Mr. Badi says,
Lordship.
then we will dispose it of giving him liberty to challenge.
Lordship,
this.
I am told it will take 3 weeks, and your lordship knows this state authority, my lord. I am being told it will be done by 3 weeks.
Mr. Badi, we will say that they will complete it within 2 weeks and
Your lordship can
Yes,
see
my
the
lord.
page 56. That
Mr.
has
Badi,
been,
how can we stop them
no,
from
they have said so. The additional increment they are going to do. Your lordship's page 56. Serial number 35, as they indicated. Your lordship got it. Serial number 35 and 29, they have indicated their communication memo.
29 and 30?
35. 29, headmaster, promotion. Now, my lord, thereafter annual increment was given.
Where do you find promotion?
Page 56 top.
Promotion.
Headmaster, promotion, promotion. Then, my lord, next below column, annual increment, annual increment, annual increment, 20 years benefit, annual increment, upgraded status of the schools. Upgraded our schools, that increment was given. Now they are going to deduct the same
My
in
lord,
view of that memo.
well, nowhere it is written, my lord.
Which memo?
Well, the 17, which the headmaster was directed to enjoy due to upgradation of the school to additional increment. That exactly says upgraded to the status of the schools.
Where is this memo of 3rd June 2016? Upgradation in status of school. Remark is memo dated 3rd June 2016.
My lord, this is the reason for termination of appointment.
Page,
This is
page
the
49. Fixation was done. How the refixation? Page 29. This was done in 2016.
Mr. Badi, how you are prejudiced?
Because of the fact that everything will go.
They cannot,
the pension.
let them come with that. They will come and say that this is the wrong fixation. You
But
must
they have said so. In the they return the file with an observations.
That is DPPG observation. He is not the pension
it is
sanction body.
unless it is completed, then my lord, I cannot
Exactly.
receive the pension.
Exactly.
Yes.
Now this after this completion, you will be able to ascertain whether there has
No,
been.
my lord, the pay fixation has already been made by the district inspector schools long back, page 26, 49. So if it is revised, then my lord, what remains? Again, I have to challenge before the court.
Yes.
When my lord, it is settled, when it has already been 2 additional increment has been, my lord, the memo, the decision of the government has been set aside by the honorable court.
The entire dispute arose
Page
because in
20,
the
page
meanwhile, my
49,
lord, there
your
was
lordship,
another circular.
Page 49, taking into 2 additional increment, the pay fixation was made. Now they are going to disturb that.
The single judge has said that you are proceeding on anticipation.
Not
Your
anticipation,
requirement is
because
April.
I tell you, Lordships, I am the headmaster. The file was written, see, asking to rectify your own pay fixes and memo. Thereafter, the district inspector will correct it.
Where is your cause of action? Rectification.
No, cause of action. Your Lordships, kindly see the cause of
This
action.
is a accounting authority. They have forwarded a
No,
statement.
my lord, your Lordships, kindly have a look, page 53 once again. Let him come.
My lord, whether this pay fixation will stand or not, my lord, the entire dispute arose because in 2017 there was another
Then,
circular.
madam,
Well, that circular went away, my lord. It was turned down by this honorable court.
How can
That-
you take into consideration that circular?
We cannot. That is the thing I am submitting, my lord. We cannot, my lord. This is
Let
the
him come with the
decision
report.
Decision can go in your favor also.
No,
Yes,
that is not because of the
That
fact.
is your anticipation.
No,
Mr.
my lord,
Bari.
it has been indicated in observation memo. Your lordships, kindly have a look. Page
If that
53, one
issue
second.
if that issue has attained finality, can they reopen?
My lord, that my lord, every day,
That is the decision of the pension sanctioning authority.
my lord, that every day we are filing this cases. Let him come with the report, or let him come with the report.
Lordship.
4 weeks.
Lordship.
Come in 4 weeks.
Lordship.
The lordship, let it be recorded. Otherwise, let them file the report.
A hard Mr. Badi and the advocate.
হবে। One thing is coming in my mind. If you Lordship can take up at 2 p.m. with Justice REETOBROTO Mitra, if we consented to this, then your Lordship can deliver the judgment. If I am not wrong, recollect, Justice Chatterjee was not there. Argument of both the sides concluded, written submission made.
Mr. Basu, not possible. We have that education matter fee. We have
No. Only for this to make it CAB, nothing else.
It cannot appear.
It has no. The supplementary list, my lord, is now it is preparing.
Only in parted matters. We have not recorded part.
But kindly see the tenor of the record.
We know.
And my learned friend will consent to that.
Argument completed.
Argument
কমিশনের মামলায় be ready to be
Normally, previously, what was the procedure? The both parties with consent write a letter.
after this order, I
এমনি চলে আসছে এমনি করে চলে আসছে গ্রেটফুল গ্রেটফুল চলে আসছে
এসে যাবে না না আবার চিঠি
একটা চিঠি করে দেয়, করে দে না বাবা, স্যার।
Mr. Roy,
একটা চিঠি করে দে।
you just give a formal letter to
Yes,
the
yes, yes, that's
secretariat
better.
today,
and I see my lord's
Along with my lord's order, it will be easier.
putting your signature and
Yes, yes,
attach.
sir.
jointly we'll pray jointly.
Once it is assigned, we will place for orders on the particular date.
Great.
Lord, similar is almost similar case is there, my lord. Technically, it is not possible.
And to dispose of the
Pathad
matter,
hoyni. Pathad, it was not pathad.
But is it
Pathad.
The same order kore debe.
much obliged?
And do you eh?
Your it cannot be heard by this bench.
Why not? Dekhi. Eh?
Because technically it is not possible in view of the fact that Honorable Justice Chatterjee order has been challenged.
Oh, I see.
And it was heard by Justice your lordship sitting with Justice Mitra, heard the matter, and your lordship kept the matter.
তাহলে
as
এরম
formal.
লেখো, the learned advocates, the
Before rising, my lord, I beg to mention item number 16, my lord.
don't mention.
My lord, what happened, my lord? I mentioned because the Ripper release, my lord. I challenge the order with order passed by my lord Justice Chatterjee, my lord.
Who is your other side?
My lord, Mr. Ekramul Bari, my lord, I talked with him, my lord.
16, 1-6.
1-6, my lord.
So your order impugned in
And let
the
me place
present.
before the Chief Justice for assignment.
Assignment.
26 এটা
এই ও কোথায় গেল? আনু আমার অ্যাপ্লিকেশনটা
Yes, call. Please don't mention.
I'm not mentioning it.
Yes, yes.
Mr. Bandopadhyay will like to make some submissions today.
Pardon?
After me, sir.
We are closing the hearing today.
Today only. Today only. he'll-
Yes, then don't mention. Okay, take your seat. When he comes, he will make his
My
argument.
lord, with leave of your lordship's court, my lord, I am not mentioning, but I am just ventilating my grievance, my lord. We 27 of the petitioners had taken out an application for inventory. My lord, the petitioners are, my lord, my lord, candidates who have been given appointments after expiry of panel.
Sorry, this
But my lord, kindly sees, my lord, but
sorry, sir. We have
one line, my lord, kindly sees, my lord, we have been appointed by order of court, my lord.
sorry, Mr. Mojumdar. Where is Mr. Mojumdar?
only one point.
Yes. Come. Mr. Sharmal, you have finished. Yes.
No, my lord, the last point, your lordship, Mr.
You have told us yesterday. Yes, Mr. Mojumdar.
That, my lord, something's to be.
No further argument on your part. Mr. Dotto, we have allowed him sufficient opportunity. Yes, Mr. Mojumdar.
My lord, only one thing the clause in the advertisement that he can opt for other councils.
Who does that?
Losses because the legible copy was probably not there to your yesterday.
For exercising of option, you showed us that.
Pointer দেখাতে পারতো আরেকটা কপি আছে তো বাবা
আচ্ছা
losses kindly see these are the advertisement notification first clause. I put a tick mark for this.
Yes.
My lords, may I have my lord's permission to address?
First point number 1. Any candidate shall be allowed to apply for the post of a primary school teacher of a particular council only against the post advertised. Particular council he can choose for the form. And then you'll also the next form fill up. Now
no, what is your interpretation? Any candidate shall be allowed to apply.
Any candidate shall be allowed to apply for the post of a primary school teacher of a particular council. The council was not fixed. He can choose any particular council. A candidate of KOLKATA council can choose for Darjeeling council. For example, I'm saying, for a particular council for the post advertised. Now your losses kindly see the application in the next.
Where?
Losses will find after email ID. Your losses will find this roll number 19. 19 stands for District Birbhum code. Roll number. Second column, your loss. Second column. This is state roll number, my lord. 19 stands for Birbhum.
Date you said that there was a unique number.
Even this roll number was treated all along by the board as unique identification number.
When the number added with this district code.
District code.
Then what is your argument?
Argument is that, my lord, a particular candidate, this number 19 or 18 denotes the particular district he applied for TAPE. Now he has been given option, he can choose another district with this roll number. That's your lordships in this application form. Kindly, my lord, go little down. Email ID.
Yes.
Just thereafter. preferred district for counseling, recommendation and appointment. If empaneled, he has chosen Kolkata. This particular candidate, I'm giving an example, chosen Kolkata.
All right. Yes.
The next one also. But all in this chart, your lordship, most of them are belongs to the other medium, or most of them chosen different districts. So number cannot be equal. Cut-off marks, no, last empanel candidate numbers. There is no cut-off number. Cannot be equal. That's our submission. And Mr. Ahmed says all are Bengali media. That's absolutely not correct. Because showing that most of the, I can give example right now to your lordships. Some of them from Bengali, Hindi medium, some of them Urdu medium, some of them Telugu medium, Santhali medium.
All right. Yes, Mr.
Lordship, with your kind permission, Mrs. Arora is online. Your Lordship had said should start.
Yes, yes.
My lords, I'm so grateful. I will be very brief and just to the point because a lot has already been addressed before my lords.
Item numbers. Mat number 1616. Mat number 1616 of 2023.
Mat 1616
of 2023.
Item number 28.
Item number 28, Lordship.
Yes, madam.
Please, my lords. My lords, I'll be very, very brief and only to the point because there's a lot that has already been addressed and it's no point in repeating the same thing all over again. My lords, the very first point that I wish to address, my lords, is that right from 1951, the Supreme Court settled a principle that if there is any allegation of fraud, coercion, duress, etc., is to be made in any pleadings, it has to be supported in material particulars. And
Yes.
there, my lords, there are two judgments of the Supreme Court. My learned colleague will pass them on. I will.
Madam, you reply, we will take note of.
Please. Yes, my lords, I will just give the citations and I leave it with the paragraphs. My learned friend will just mark the paragraphs and give it to my lords. I do not wish to this thing. Now,
Yes,
my lord, right in 1951, the Supreme Court said that if there is an allegation that is made in respect of fraud, coercion, duress, there has to be proper case. It has to be supported in material particulars. I will just read 3 lines of that judgment of 1951.
We accept your argument. It has to be.
I am grateful. I am grateful. My lords, I need not go further. Now, my lords, I respectfully submit that the writ petition as was filed before this honorable court, of which the impugned judgment is the one which is under challenge before my lords, is bereft of any material particulars of so-called corruption or any kind of particulars to show that there was some case that was made out which would clearly establish that there was a corruption or there was a fraudulent action on any of the candidates. This I go back to the learned single judge. My lords, my next submission taking up on this is, and I say this with all humility at my command, and I don't intend to be rude, but if we look at the judgment of the learned single judge, my lords, it appears, and I say this with humility, and I repeat that, it is like prosecutor and judge in one. And that, my lords, is definitely not permissible in a rule of law. First of all, there was no material. The learned judge relies upon some sampler material, which the learned judge finds. So he takes on some kind of an investigation, and then he carries on the cross-examination of certain interviewers by himself, to which none of us who are the affected parties were a party or could have even asked any question. And on that sample material of about 30 odd investigators, and something like, I did a calculation of the numbers of the candidates in respect of which the learned judge has observed, is 0.03% of the total candidates who had taken the exam. And on that basis, the learned judge arrives at a conclusion that there is far-reaching corruption and the entire exam of 32,000 who had been appointed should be set aside. My lords, today, when we are before my lords, The assumptions and the presumptions that the learned judge proceeded with have now been found to be incorrect in view of that charge sheet that has now been filed, where none of these allegations of corruption against any one of these 32,000 candidates has been made out. So, my lords, at the first instance, entertaining the petition was completely wrong, contrary to the principles that the courts have held in the cases of fraud, duress, coercion, etc., no material particulars. In a writ jurisdiction, the honorable judge could not have become an investigator, prosecutor, and a judge by himself. And in any case, the observations and findings of the learned judge have today been disproved by investigation, by an agency which has today investigated and found no allegation against us 32,000 odd candidates, my lords, and there is nothing which is against them. Now, my lords, I submit that's my very first point on the background that I wish to place before my lords, that in view of this fact today, after having put in more than 8 years of service, to say that today all of them should be, my lords, asked to go would be extremely harsh and punitive without there being an iota of material or evidence on record. On the contrary, the contra evidence is there on record. Secondly, my lords, I believe, and that is what I have been instructed, that there has been much emphasis to connect this matter with the 269 TET candidates who were given one grace mark and the 94 other participants who were not qualified. My lords, I would most respectfully submit that both those matters are today's subject matter before the Supreme Court, number one. And hence, this court, with due respect, may not want to go into that particular issue once that is seized off by the Honorable Supreme Court. My lords, number two, neither the 269 nor the 94 form part of us 32,000 selected candidates in this process. Now, clearly, if they are not a part of this, I fail to understand in what context is the reliance being placed on those particular candidates who are not part, who do not form part of the 32,000.
Now, why do you say they are not a part of that? Because
my lords, the 32,000 who have been selected here, these are the ones who have been through the process of having the qualification of TET exam. So the 94 clearly do not have the TET qualification. They are the ones who are not qualified.
No, you have given candidates appointment by giving a grace mark.
I agree, but my lords, these 32,000
applied in respect of all the persons.
My lords, no. So far as we are concerned, there those people had not qualified the TET. They were given one grace mark and made to qualify. But here in our case, all of us are TET qualified. We didn't need any grace marks to be here. We didn't need any grace marks to have qualified this particular exam. We came on our own merit. We had the necessary eligibility and the qualification. Our documents and our papers were verified, and thereafter we were subjected to the interview as well as, my lords, the subject matter of our ability to impart education, the two tests of 10 marks each, 5 marks each, we were subjected to that. So, my lords, we are not in those category at all.
What about the 94 you were saying?
My lords, 94 are the ones who do not have TET qualification at all. They are not qualified. Their case was they were unqualified candidates. They were not TET qualified. They were only trained but not TET qualified. And by which time the NCTE had clearly made that TET was an essential qualification for purpose of appointment of teachers.
All right, madam. Anything else?
So, my lords, just two more very small points, and I will not dilate too long on that. My lords, issue were raised to say that the Tripura judgment, and there is similarity between the Tripura and the present matter, and in the Tripura case, the High Court had actually quashed all those appointments. My lords, I want to say there are major distinctions between the Tripura case and this case. First of all, in the Tripura case, there was a challenge to the constitutional validity of employment policy of that state itself. And my lords, that policy was contrary to the NCTE. Now, that is not the case before my lords at all. There is no constitutional validity challenge to any provisions or any rules. Number two, in the case at hand before my lords, the appointments are strictly as per NCTE guidelines so far as qualifications of the candidate, etc. are concerned. In Tripura case, in facts, the procedure was contrary to the provisions of National Council for Teachers of Education Act, which is a very important factor. Now, my lords, in our case, all the candidates have qualified, who are appearing before my lords, have passed the eligibility TET 2014. So, and after that, our academic marks were computed on a proportionate basis. We underwent the verification of all our documents, scrutiny, etc. And then, my lords, we participated in the interview and the aptitude.
Yes.
But in the Tripura case, my lords, there was only one interview that was conducted and nothing more was done. And it was a highly discretionary thing, which was the finding of the court, but more particularly, it violated the NCTE guidelines, which are the central government guidelines for appointment of teachers. So one could not have gone contrary to that. One could not have gone contrary to the qualifications prescribed in the NCTE guideline. My lords, so far as the appointments are concerned, as my lords have now seen, and the chart sheet has been shown very extensively to my lords, there is no illegal appointments that have been found. Whereas in the Tripura matter, the selection and the appointments were found to be illegal. On the contrary, the learned single judge, based on a small data, a very, very small data, which was in a very summary inquiry, if I may say that, in a very summary nature. My lords, in a 226, one can't have an inquiry. 226 does not envisage that kind of an inquiry. Today, there is an investigation and a detailed inquiry, and which has categorically found that, my lords, there is no element of corruption, there is no element of complicity or to corruption here at all. My lords, the third point that I'll be very, very quick with is that a lot of parity was sought to be drawn with the SSC case. Because in the SSC case, the Supreme Court had set aside all the appointments. Now, there's a huge distinction and they're completely different and distinct. My lords, we must remember that in the SSC case, there was a written exam. Here, we have an interview and an aptitude test, and then we have a prior TET qualification, verification of our credentials, our documents, and thereafter we go for interview and our aptitude. In SSC case, I beg your pardon. My lords, that's my Delhi pollution showing up. So, my lords, in the SSC case, there were OMR sheets. In the OMR sheets, it was found on a fairly large number that there was actual manipulation. There was a CBI inquiry. The CBI inquiry actually reported manipulation of the OMR sheets. Now, my lords, please contradistinct that with the present case. In the present case, there is no written exam. There is no such manipulation of any answer sheets. And the investigation today has submitted a report which does not show any complicity on part of the candidates. So, my lords, to draw a parity or to draw anything from SSC exam, my lords, would be, SSC candidates would be completely, my lords, misplaced, number one, and will not fit into the present case at all. That's another fact situation altogether. My lords, lastly, I would want to make a submission. My lords, there has been that can number 2 and 3, where certain documents are sought to be placed before my lords for the first time. My lords, apart from the fact that it has been said on this side that those documents are forged or they are not documents which are correct in nature. But I would, my lords, ask myself a question. At this stage, in an appeal, would my lords, without having any verification of those documents, allow such documents to be placed before my lords and to be considered? Then, my lords, I would most humbly submit to you that we fall into the same trap as the learned single judge did, because he went on the basis, and I would say that with all humility, he went on the basis of what was produced before him. And that has today been disproved by a detailed investigation. Similarly, these documents which are sought to be placed for the first time before yourself, having not been verified, not been authenticated, and specifically being alleged by the present petitioners before my lords as being forged and fabricated documents, I would request, my lords, that the court may proceed on the basis of the record that has come from the learned single judge, and please do not allow any fresh document or material to be taken on record at the stage of the appeal, my lords. My lords, I will lastly, I would, my lords, there was one other judgment, but I don't think that is necessary, that the honorable single judge could not have gone on the basis of any newspaper reports, because my lords have said it time and again that the courts will not take cognizance of an issues merely because they have been published, and that's not an evidence. That's really not an evidence.
Why you are saying newspaper report? It was not there before the single judge.
My lords, the learned single judge in his judgment and in those proceedings made observations that there's a lot of newspaper publications about alleged corruption and everything else. Now, my lords have held categorically, the Supreme Court held in large number of judgments that mere newspaper publications are not enough evidence to arrive at a conclusion or arrive at a determination that there is an evidence of, let me say, corruption or something. I'll just give my lords a citation. It's a 2020 volume 16 SCC 811. That's a more recent one. And the relevant paragraph will be 6 in that. My learned colleague will hand over that. So, my lords, but that's on the side wing today. It's an outlier, if I may say, at best. The core of the matter would be that there is today no material whatsoever to show that there was any kind of a corruption in this particular examination process, my lords. My lords, I'm extremely grateful for your time. I'm very much obliged, my lords.
15 to 20 minutes, not more than that.
Mr. Bandyopadhyay, then you address what Mr. Mojumdar.
My lord, I addressed first. Your lordship said to me, "Man, I cannot sit here every day."
All right, tell it.
Not sit every day. The my lord, first point that was hard, but at the initially I have argued that regarding this extension, relaxation in training, that relaxation in training was given by the MHRD till 31st March 2016 and 26 September. There was no relaxation, hence the board could not have appointed. This is the argument. Now, your lordships will find that the rules relating to 2000 recruitment process do you have the extra copies?
2000 recruitment process.
2016 recruitment rules.
Yes.
The process were enacted on 2nd March 2016.
Yes.
And when the relaxation was still in existence. Okay.
Yes.
Now, Rule 6.3 provided for the appointment of candidates with relaxed qualifications, untrained after the appointment of trained candidates. That your lordship on the paper book, but Rule 6.3 at page 114 of the paper book.
Yes,
that is there. If required, I will hand over.
No, it is with us.
There was relaxation was extended time to time, and within the extended time, all our clients, all these persons who are there, they have what they
were participating.
And to who will get this relaxation? Those who are appointed, not each and everyone. Those who are appointed as teachers. After appointment, they will get it. They get the and they have done it. Therefore, they did not have the qualification. It's not that. And in the advertisement, I have pointed out. I do not wish to again that in the advertisement itself, it was said that this qualification has to be obtained within 2 years after appointment.
Yes.
This is one of
that is not disputed.
that is no dispute. Therefore, we are all trained. Now, my lord, one I have shown it also. Again, I am sorry, my lord, repeating. The Honorable High Court of Calcutta in WPS so and so Chinmoy Doli case permitted the state of West Bengal to appoint untrained candidates. The court's order is there. Untrained candidates as assistant teacher in primary school even after the period of 30.
That is
This is also not this, but they have raised the issue. That's the reason. The point is this, my lord, point is very limited. But with great respect to our learned friends, they wanted to make it more wide. But we do not have to go that such stage. Point is very limited, but they have traveled hither and thither, hither and thither. Naturally, if I don't give the answer, my lord, your lordships will say that I don't have any answer. I have appointed, I would not have given the reply unless the Mr. Bhattacharya had traveled so much. He is my senior.
That will be answered by Mr. Bhattacharya.
He is not there. Mr. Bhattacharya traveled so much. And in practically, he is so from Vietnam to Platinum, everywhere he has traveled.
That is not at least relatable to this case.
No, not relatable. Just Mr. Bhattacharya is there.
Entire proceeding becomes boring.
Yes, yes. At least with us. Compilation. That is, I objected to your lordships. Observe that you will be given the chance. Lord, what is the law of pleading? Even in a writ petition, even law of pleading is very clear.
That you have extensively argued.
Bharat Singh's case, I have argued that.
Yes.
Beyond that, no one can go. After completion, bar from the bar, one compilation will be handed over, which has become very practice of nowadays. And then in that compilation, so many documents will be given. That is not the practice. That is not the law of pleading. That is not the rule of law. In court, we have to be precise with the pleadings and the evidences annexed thereto. Beseech to your lordships, I will request to your lordships not to look into any other documents in this matter, excepting which are in pleading, or which were only in pleading. Even if the learned single judge has committed a mistake,
yes,
by looking into that documents which are not part of the records, and for that reason which have not been allowed to revert even the other sides, these documents cannot be. And my lord, kindly remember one thing, that the first time we are before your lordships, we are not in the trial court. No, we didn't get any chance. And at the time of argument, the documents are being handed over. How we will deal with? Not a single document.
Yes.
My lord, Mr. Bhattacharya relied on Standard Chartered Bank's case.
Yes.
That is 2006 SCC 94.
Deemed pleading.
Yes, was rendered in an appeal under Section 10 of the Special Court Trial of Offence related to Transaction and Security Act 1992, Para 1. It was a suit wherein the deficiency of the pleadings can be covered by the evidence, but in the writ proceeding being summary in nature, such recourse cannot be permitted. There is a deficiency in pleadings. My lord, every witness have come. There is a scope to cross-examine, etc. Let's assume a pleading has been made vague.
No, it was a case under the Special Act.
Special Act. That's
What
time.
suit why you're saying?
No, Special Court.
Special Court.
Section 10 of the Special Court Trial of
A
Offence.
suit.
No, evidence was taken. Evidence was taken. That was judgment.
Evidence was taken.
Evidence was taken.
But it was not.
Not true. Sorry. Wrong.
Yes.
Now, therefore, there the evidence. Why this evidence is coming court, regular court, that's a different part. Everyone is getting a chance. Then I can ask for this, all right, if with the entry being all persons, I will cross-examine them. Your lordship.
Mr. Bhattacharya's argument, if we are not mistaken, his argument was what are the elements involved in this matter? It encompasses corruption, fraud, etc. So, Mr. Bhattacharya argued that it is a settled proposition of law that suppose A, B, C pleading is required. You have made A and B. You have made pleading as A and B. So, for the specific C pleading, you need not reject it on the ground that there is strictly no pleading to that.
Lord, what is a pleading in a writ proceeding? Can it be vague?
No, on the contrary, your argument is that the original pleading remained. There was no amendment to it.
No.
What was been done? What has been done in this course of action, deemed pleading would not apply.
May I, in short, his case, kindly see what he is asking for, what their clients are asking for.
Yes, sir.
Their clients sought for certain
Similar
considerations. Their clients did not ask for cancellation of any of the employment.
Yes, yes.
Correct. Now, when they have not got it, now they are saying, since I have not got it, soon no one will get it in West Bengal. I have become unsuccessful. Naturally, you will not be no one. And this word is very spicy word, the corruption. Corruption has to be proved. This is in Bengali, which is called chutney.
Yes.
The point, therefore, is before a lordship, whether before the single judge any corruption was proved.
Yes.
Not a one chain. It is a complete, corruption means a complete chain, not the picking up of the one thing.
Yes, Mr. Bhattacharya.
Now, is there any case has been made out that these my clients have given money and got the employment or not? In the gist.
Yes.
That corruption has been proved. That CBI has said.
Yes.
Some persons have got it. Who are the persons? Dealing with the 32,000 cases. 32,000 persons future. Now, next one is charge sheet of the CBI. I have argued extensively the charge sheet of cited the judgment to your lordships also. Judgment I have cited. It's an opinion only. That has to be proved. I cited the judgments. I do not want to repeat. Your lordships will, when you like, can an opinion can be relied upon to terminate the service?
Yes.
In our compilation, I have given it 2022.
What is the name?
Volume 12. There is Rajesh Jadhav and another versus State of Uttar Pradesh. Come to paragraph.
So Rajesh Jadhav.
I have cited Millard. I have given a separate compilation of
No. We have taken note of. You have cited Institute of Chartered Accountant, then Khetrobasi Biswal, Boluram, then Ranjan Kumar.
These are
This
different
Raj,
parts.
what did you say? Printers Mysore, Chennai Metropolitan.
This is different.
Murli Babu.
Ogulo delay.
No delay. Yes. Now this charge sheet is an opinion you have not given.
No, Miller, I have cited that. Miller, your lordships
Can
will
you
find
give
it.
us the reference, please?
We will get it in my compilation.
2000.
344. My compilation 344. That is at page.
No, the name of
2022 volume 12 SCC page 200. Rajesh Jadhav and বড্ড কথা বলছিস
SCC page 200.
আমি একটু ডাল হেডেড ভাই
Yes.
Problem 2022 volume 12 SCC page 200 paragraph milord 27 তাই তো 7 paragraph 27
all right. Yes,
but just want to remind to this proposal milord section 173 CRPC calls upon the investigator to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer on the materials collected by him. He takes note of the offense and thereafter conducts an investigation to identify the offense, the truth of which ones. Therefore, it would be lead to the position that the evidence of the investigating officer evidence of the investigating officer is not indispensable. The evidence is required for corroboration and contradiction of the other materials witness, as is the whole links and presence. Even assuming that the investigating officer has not deposed before the court or he has not cooperated.
Yes.
Now, therefore, it is an opinion stage. Trial has not yet been concluded.
It is tentative.
Trial has not been concluded. Therefore, your lordships, the corruption charges have been made. Let's take it. Your lordship is deciding the case in the civil side when charges have not been proved. On the contrary, today, what we see, all the accused have been enlarged on bail. That doesn't mean he has not committed an offense. I am not saying that. Also, I am saying that doesn't mean the charge sheet is given, that's a sacrosanct.
Yes.
Now, my lord, if the CBI was really serious, take the case, my lord. If the CBI was serious, this case is now pending for 4 or 5 years. They could not have finished the trial.
That is a
separate thing. But I am saying, my lord,
we understood your
corruption. We are saying of corruption will not do. That's a separate issue. But I am saying so, my lord, because these are the very corruption. To prejudice a court is this word is sufficient. But court will look into that, whether corruption has been established or not. That's my submission.
Yes, Mr. Wanda.
And the corruption has vitiated the selection process. Maybe corruption, but here the corruption has vitiated the selection process or not.
Yes.
Right? Now, my lord, next.
What do next?
দরকার নেই তো এটা বলা হয় Namely, the litigations for 6 marks have been taken an argument. 6 marks have been granted. Charge sheet has been shown that the 6 marks have been given extra. Correct? That has been pointed out also. My lord, kindly remember, my lord, I can give the references also. This litigation for granting 6 marks, lead matter Pratibha Mondal versus State of West Bengal were moved by Mr. Vikasanand Bhattacharjee, Mr. Samim Ahmed, Mr. Sudipto Dasgupta, Mr. Firdaus Samin. They got the order from the High Court, 6 marks to be added.
Yes.
And in the charge sheet has said extra marks, 6 marks have been given.
Very good.
কি দরকার জজসাহেব এখন তার চার্জ শিট দেখাতে গেলে তো হবে না it will take time 15.
Yes,
but I will give this orders copy. I will give it to your lordship. Who got this order from this court?
No, Mr. Bondo, that is not required because your argument is that it is an charge sheet is an opinion, it is tentative on the basis of that is your argument.
Very nice. I am just
no, as you are.
My lord, I am who is on which side is very difficult now to understand.
Track it.
for not conducting the aptitude test, then selection, cancel of the selection process only for untreated candidate is only bad in law. Untrained, trained, all, everything will go. This is practically possible now at this stage to after 2016 to 2025.
Because the trend also faced aptitude test.
Yes, same. Only extra, the trained is also having the certificate. We untrained also obtain the certificate. Therefore, your lordship is facing with the problem. If this acceptance is taken away, then more than 60,000 teachers will go. 42,000, sorry, my lord. Not only us. Neither untrained was made party, neither trained was made party before the single judge.
Yes.
And unfortunately, my lord, this is a very unfortunate for us. Although the board is represented by here the Honorable Advocate General.
He has left.
No. I will not blame him because he was not there at the initial stage. Neither Mr. Rahul. Ratul was there in the see the proceeding. From the very beginning, board did not contest the case at all. Not a single thing has been said. The council who appeared at that point of time.
He put this question to Mr. Dotto.
Our anxiety is that, my lord, everyone was not required to be calm before the court. But when states and the state authorities are represented, my lord, my lord, society expects everybody's case will be argued properly.
Yes, Mr. Bole.
Next point, my lord. Citing examples of few irregularities cannot be ground for setting aside of the 2000 selection process.
Citing?
Few candidates.
Oh, yes. Yes. That you have argued, Mr. Bond.
No, this point I did not argue. They have taken, but it was Lordship's point. My lord, it was your Lord's, my lord Justice Chakraborty's point. Lordships have argued. I am grateful to your Lordship.
No, we have not argued.
Not argued. Your Lordship have, Lordship.
No,
not argued, not. I am sorry, missing.
Yeah, yes, sorry. Mr. Anindo Mitra and
no. Here this observation had fallen from your Lordship.
No observation.
Very good. I am with you.
No.
Very nice. Now, few incidents.
Yes.
Can it be a ground? Few incidents.
Yes, it is.
Then when you are taking the 32,000 employment, you prove it 32,000 case.
Yes.
After all, it is a litigation.
Yes, Mr.
This I am coming. Documents regarding publication of panel. The writ petition, kindly see. Writ petition itself in 2009, Miller Pub. 19.
Monica Das. Or Robiul Sheikh.
Niladri Jana.
In the bunch of Robiul Sheikh.
In the bunch of Robiul Sheikh.
Huh?
Here is hard with Robiul Sheikh.
It was hard with Robiul Sheikh.
Oh, it was hard with Robiul Sheikh?
Yes.
Yes. What you are
saying? Robiul Sheikh and MITRA.
Are tu ekhan থেকে দেখা না তুই অন্য জায়গায়
paragraph 35, 25 and 26 annexure আছে
annexure দেখা 35 paragraph 35 I'm আর কপি আছে your petitioner says
আপনার জন্য আছে এখানে
কোথায় কি রাখছিস
paragraph 35
হ্যাঁ paragraph 35 of this
of Robiul Sheikh
Niladri tagged matter Niladri
one judgment was delivered
Niladri Jana but I am saying the petition
matter tagged with Robiul Sheikh but the judgment was only in respect of Robiul.
Common judgment.
Please, please check up. I think it is only Robiul.
Dekhin sir. Robiul Sheikh sathe Niladri Jana.
No. Robiul Sheikh with the Niladri Jana. It is there. 2023 SCC online page 710.
Where you are showing?
Pilot, kindly come to paragraph 35, na?
35.
Paragraph 35. Your petitioner states that from the published panel of the district Dakshin Dinajpur, it has been seen the lowest score obtained by candidates are untouched is 16,000.436 over the lower course score so and so. The untouched your petitioner states that those marks are higher than. Then, unless you have seen the panel, how can you do it? How can you make this pleading? Next paragraph is
25, 26.
25 তো পড়া হয়ে গেল, 35 তো পড়লাম, তাহলে কোনটা?
প্যানেল গুলো 124 থেকে
Malad, kindly come to page 124. It's not readable, but see, from 124 the panel has been annexed.
ইন্ডেক্সে লেখা আছে
Panel, and kindly see in the index.
ব্যাচ ম্যাটার list of the photocopy of list.
Malad, kindly come at the top of the
The judgment, was it a same
batch matter, batch matter. Malad, this is a
page 124.
Yes.
This has been told to us, Mr. Bandyopadhyay, that the panels were annexed with those.
Yes. Therefore, the panel was not published, it was not the case. আরো বেশি বলিস না, জজ সাহেব বেশি চাইছি না। বোর্ড বলে দিয়েছে, এগুলো বলে দিয়েছে বিকাশ বলে দিয়েছে। But these are the points, almost every other, my other friends all have dealt with. I don't need to repeat it. Lord, I will just beseech to your lordships, I will sum up and I will say to your lordships.
Yes.
Kindly just. My lord, these 32,000 persons had been employed right for 2016. 17. And 2000 selection for 2017. This is continuing. First round litigation, second round litigation, all have gone. Very recent, Justice Joymallo Bagchi's judgment, did I cite it? Justice Joymallo, precedent, one of the judgment I cited, that is delivered in the Supreme Court by Justice Joymallo Bagchi. Binding precedent has to be followed. Litigants should not be forum shopper. Renuka versus State of Karnataka. 2025 SCC online SC 970. Now, when Justice Mousumi Bhattacharya was taking matter, 970. Paragraph 17. I cited this judgment.
That was a coordinate versus coordinate, not a single bench versus coordinate.
No. What is the proposition of law has
proposition is if you are not agreeing with a single judge.
Proposition binding effective. See, proposition.
That is
binding effect is there. The one of the word used expression has been used forum suffer, which is applicable in this case. There are a number of judges who have taken the matters of this. Not removed. Justice Mousumi Bhattacharya, Justice Amrita Sinha, even my Lord Justice TAPABRATA Chakraborty was sitting singly. Even my Lord Justice.
Take up this matter.
No. Education matter you had taken, na? That time it was not moved. I am saying it was not moved. That is, I am not moved. I am saying that. Then Justice Orijit Banerjee, Justice Hiranmoy Bhattacharya, the moment this jurisdiction has come, all that petition, this is called forum shopping. This is what I am not on that. I am not. I am using a legal expression, my lord.
Forum shopping. Yes.
Right, forum shopping. I am not interested in any name. This name has no value now today. Now, my lord, next is. Now this is continuing, my lord. Would your lordships kindly consider? My lord, consideration before your lordship is this: whether the matter was decided in accordance with law by the court by applying all principles of law. By applying all principles of law.
Yes.
Or whether the single judge has adopted a procedure which is unknown to the settled law.
Yes.
If it is not decided on the basis of the law fixed, it is taking away of the livelihood of others. My lord, 32,000 not before your lordships. 32 into 5. 1,60,000, 70,000 livelihood are at stake.
Yes.
Lord, this is my judgment. I'm just so grateful, deeply obliged. You all lordships are so kind to me, accommodated me. I am deeply obliged to my Lord Justice.
We accommodated everybody.
No, even then you were lordship today. No, I express, at least allow me to express my gratitude.
No, not that. This is the usual practice.
No, I express my gratitude.
You had been serious. Mr. Bhattacharya is there, Mr. Bandyopadhyay. Both of you are senior.
Well, and apart from that, you are so kind.
No, it's about kind.
Your magnanimity kind.
কত তলোয়ার নিয়ে আসছে Mr. Mojumdar, make it short.
I will try to make it as short as possible.
Yes.
Well, first, my lord, I am going to address on the issue of, but other my lord, I will reiterate just a brief recap of my submissions regarding publication of panel. Well, I made these submissions, but just a quick recap. Lordship will kindly take first Rule 2L of the recruitment.
Mr. Mojumdar, we have taken note of.
Your Lordship has taken note of Rule 2L.
Yes.
Then Rule 8.5.
Yes.
Then Rule 9, Rule 10, and Section 60, subsection 2, Clause K.
Yes.
Which gives the my lord, which vests the district primary school council to issue appointment letters. Well, my submission in short was that, my lord, Rule 2L says that panel will be published according to the rules in the manner as prescribed. There is no prescription by rules in the 2016 rules. So I cited one judgment rendered by the Honorable Supreme Court, 87-1 SCC, page 658. That is B.K. Srinivasan versus State of Karnataka. But this was not in my compilation, but I cited, my lord, I just handed up a copy. 2 copies to your lordships. পিটিশনগুলোতে ওই দুটো পিটিশন, ওই একটা তো দেখেছি, আরেকটা ওই কি জানো ওই মনিকাটাতে। Kindly take my lord 87. I have brought copy.
Just a minute.
I am sorry, my lord.
Paragraph 15.
Paragraph 50. Well, I am sorry, my lord. I am troubling your lordship. Rather, we have tested your lordship's patience to a great extent. But it's like elasticity of your lordship's patience. Paragraph 15. My lord has got that?
Paragraph 15.
15. Man, may I hand up a copy to your lordship, subject to lordship's kind consideration? Which clearly says, my lord, it may be published in official gazette or by any other reasonable means. Here, my lord, since DPSC is the appointing authority and the panel is approved by the board, then it is sent to the district primary council, and the district primary council publish the panels and put up the panels on the billboards of the respective notice boards of the office, in the office of the district primary council. Admittedly, my lord, there are 2 sets of writ petition. One Rubiul Sheikh with 5 others, I believe, right? And another one in 2017, that is Monica Das. Monica Das paragraph ta bola. Just give me that paragraph. Panels were sent. And my lord,
that is in Monica's which paragraph?
Monica's page 16, paragraph 12. My lord, even the it was a lengthy petition, and panel is also annexed. My lord, we have got copies of
that
the
has
petition.
been told to us. That is
yes.
Yes.
But may I just hand up a copy? Just Not necessary or not necessary? কে আছে? কে?
In the writ petition, the panels were annexed.
So the panels were available, were accessible.
That Mr. Bhattacharya
Stated that this is not publication in terms of the rules.
whatever has been annexed, that is a list of names, not a
Well,
pattern.
it were panel. Kindly take the, can I take the panels? The panels were published. Well, what does panel would mean? Panel would mean the list of the successful candidates.
Exactly.
Nothing more. Well, we
Yes.
may use different jargons, but this is the upshot of the entire matter. Now,
yes,
and my lord, in Robiul Sheikh and that batch matter, my lord, this from different districts, different petitioners were there. My lord, from 20 districts or such.
You have given some of the writ
My lord,
petitioners.
so my lord,
were
I don't want to waste your lordship's time, and I made my submissions.
Yes.
So my lord, and my lord, when their turn came, my lord, this submission was not countered by any of the respondents in the appeal before your lordship, or even the added applicants.
Yes.
There was no rebuttal. Now, my lord, now,
Yes, Mr.
my next endeavor would be, well, it's very strange, my lord, just 1 minute of your lordship's time it would take. My lord, the applicants and some of the petitioner or some of the other applicants rely on 2 sets of documents. One, affidavit of agency. I will not elaborate on that. Second, charge sheet till the 3rd supplementary charge sheet. It is very strange, my lord. The applicants on one hand are relying on the affidavit of agency, which is an accused in a criminal case. And on the other hand, they are relying on the final reports or supplementary reports of the investigating agency who is investigating the said accused.
Yes.
So, my lord, in that event, can they rely on any statement made by the accused in a criminal case when the reports are ready? The reports would speak for themselves. Reports are public documents. And now, my lord, I take your lordship to the charge sheets. I think that will explain it all. Kindly take, my lord, the CRM number. It's part of the criminal case, this criminal motion. Kindly take, my lord, how this investigation was initiated. What is the starting material source of this?
Why you are going into
Well,
that?
I have to go into this because, my lord, they relied on this and I want to also rely on that. It's very strange, my lord.
No, we allowed Mr. Bhattacharya to rely since it was a charge sheet.
Yes.
It can be availed by anybody.
Yes, my lord. I also want to rely on it.
Kindly, it was extensively placed yesterday. You
My
were
lord,
there, Mr. Mujumdar.
My lord, yesterday supplementary charge sheets were placed.
Right, you tell us the page number.
I will give your lordship the page numbers, my lord, kindly, and I will place somewhat in detail the 4th supplementary charge sheet, which is till now the final charge sheet, which has not been placed at length. Where, my lord, this identity of the 270 candidates or 264 candidates and identity of these 96 or 94 candidates has been clearly specified, and so we know who are those people.
Can you show us that portion?
My lord, I will come to that.
Identification portion.
Kindly.
Because Mr. Dotto submitted to
The lordship doesn't have the entire charge sheet. 4th supplementary charge sheet, the lordship has got entirety.
My lord, certified copy, my lord, I handed over a certified copy of the charge sheet yesterday.
We have ওটা আমার ওখান থেকে আনা any copies we will see.
এই একটা কপি দিয়ে দেও ওদের। আমি দিয়ে দিচ্ছি তোকে। হ্যাঁ, করে পাঠিয়ে দেবো, কোনো অসুবিধা নেই।
This is the 4th charge sheet.
This is the 4th supplementary charge sheet, where, my lord, why I wanted to compare the first charge sheet in the point of time with 4th charge sheet with the 4th charge sheet to place before your lordship or to buttress my contention that what was the allegations which were made initially, most of the Give me 1 second, my lord. Just give me 1 second. Charge sheet September 20. Kindly take the charge sheet. Ekta copy deto. My lord, kindly take, my lord, first paragraph 9 of the charge sheet, of the fourth charge sheet. Yes. My lord, paragraph 8 would be very important in the sense, my lord, they identify the total number of candidates who got appointment. So all the materials, paragraph 8 at page 17, running page 17 of this document. My lord has got that? Your lordship will find there is a table.
Yes.
Table covering 21 districts and the total number of candidates who got appointment. 42083. My lord has got that? Now, my lord, kindly take 9, paragraph 9. It has already been mentioned in the first supplementary charge sheet that the original as well as the scanned copies of OMR sheets, my lord, these OMR sheets are the 2014 TET OMR sheets.
Those are not with.
Yes. My lord, that writ petition is pending. It is pending in the matter of Shantanu sheet. It is pending before the Honorable Single Judge, where, my lord, the state 2014 examination is under challenge.
Just.
Dao, Shantanu sheet order dao.
No further.
No, it is there. It is there. No further compilation, my lord.
State 2014 is under challenge.
State 2014 is under challenge.
What is the name you said?
Shantanu sheet. My lord, may I give the WPA number?
Shantanu sheet.
And some others, Devabroto Das, etc. Several writ petitions are there.
In TET, that OMR.
OMR TET 2014, yes, everything is under challenge. The matter is pending before the Honorable Single Judge. The Honorable Single Judge adjourned the matter due to pendency of the.
No.
Oh, it has to be taken up. This court is, however, of the view that the propriety of TET 2014 examination would still require inquiry in these writ petitions, irrespective of the proceedings before the Honorable Division Bench. So the Division Bench is this matter. No, tale konta. Yes, this matter.
That's a very good, sir. Your contention is that was OMR pertaining.
Yes, madam, that is TET 2014.
Issue is pending before another judicial.
Yes, other judicial forum.
Yes.
So, my lord, in these proceedings, my lord, so far
42,000 includes the 38,000.
32,000. Now kindly take paragraph 9. It has already been mentioned in the first supplementary charge sheet that the original as well as the scanned copies of the OMR sheets were destroyed by Messrs. S. Basura and company as instructed by WBBPE. Hence, the roll numbers of the aforementioned appointed candidates received from DPSCs were compared with the TET 2014 result seized from NIC. It emerged out that out of 42083 candidates, 431 candidates were those who had not qualified in TET 2014 examination. It further emerged that out of these 431 candidates, 71 candidates were those who had been declared qualified in TET 2014 at a later date on the basis of order of the Honorable Court, High Court at Calcutta, and also after re-evaluation of OMRs. Thus, this is the most important sentence so far as this paragraph is concerned. Thus, only 360 candidates who had not qualified were found to have been appointed. So, now kindly turn over and take paragraph 15. Where, my lord, this 1 mark issue is considered.
Paragraph 16.
15, my lord. I'm sorry, my lord. 15. My lord has got that?
Yes.
May I just read it out? Investigation has further revealed that numerous candidates had represented to the WBBPE and a few had moved petitions in the Honorable High Court at Calcutta that a particular question, number 6 in the JGB booklet, number 4 in so-and-so booklet in Bengali medium paper, and had 2 correct answers, option A and B, and only those candidates who had marked option B had been awarded a mark, while those who had marked option A had not been awarded the same. It has emerged that on 2011-2017, Mala, kindly mark the date. On 2011-2017, a resolution was passed by West Bengal board. This is the board in a meeting presided over by this Manik Bhattacharya, that such candidates who had marked option A would also be awarded 1 mark, provided that the candidate should be, Malad, kindly take, the candidate should be eye trained. II fell short to qualify by 0.1 mark. III had written the examination in Bengali medium. 4 had marked option A. One of the criterion was that the candidate has to be trained. The meeting took place on 20th November 2017, and all my appellants before your lordship were appointed during the period February to April 2017. Long after, when we are already, we are already working as primary teachers in different schools. But the scam, Alex scam, whatever the scam they say, the scam or the allegations pertain to a period which is post-selection, actual selection.
You have said this.
Yes, mother. Now kindly take, it has emerged that a note was put up by Manik Bhattacharya to the Principal Secretary Education Department with copy of the resolution and expert opinion for further processing in ministry. Finally, the note was approved by Partho Chatterjee, the then Minister of Education, Government of West Bengal, on 22, Mala, again mark the date, my lord, 22/11/2017. Accordingly, on 30/11/2017, another resolution was passed by WBBPE to the effect that Department of School Education had approved the recommendation of award of 1 mark to the eligible candidates. It is also mentioned in the said resolution that the Secretary of the Board had submitted a note for consideration and acceptance by the board. As per the note, 270 candidates met the aforementioned 4 criteria decided in the resolution dated 2011-2017, and also enclosed the breakup of such number of candidates district-wise. It has emerged that no such note of the Secretary of the Board was kept on the file, and the details of the 270 candidates like roll numbers, father's name, etc. have also not been entered in the resolution register. This act shows that the entire omission was a deliberate act on the part of Manik Bhattacharya only to avoid detection and keep the entire act of commission discreet. The district-wise number of such candidates mentioned there as follows. So, Malad, the district-wise number is also there. Now, Malad, kindly takes paragraph 16. It has emerged during investigation that actually 428 candidates fell in these categories, and therefore 1 mark should have been awarded to all of them. However,
why you are placing? It has been the submission. We have taken note that 294, that was 270 plus 94.
My lord, why I am placing
the ultimately your contention is the chart investigation has boiled down to this issue.
Yes.
That at best, if there had been irregularity, that is pertaining to those 2 categories, and we are appointed prior thereto, we are not particular.
My lord, I am trying to, why I am making this submission? Just 1 minute. I am making this submission for the reason that once these candidates are identified, but the names are there, your lordship will find at paragraph 17.
Yes.
Once these names are identified, the candidates are identified, both in the category of 270 and 94. My lord, then there remains not even a cavil that the 32,000 candidates.
You made that submission. Scam at best, if any, is pertaining to 270.
But at that stage, my lord, we did not have the identity of
that is fortified by this chart sheet,
that
which
is
has been
fortified
given.
by this chart.
Thank you.
Kindly
Yes.
take paragraph 17 only. I am not placing. Paragraph 17 for these 264, 270 candidates. Now, my lord, kindly take, goes on. Kindly take paragraph 18, which gives a list of 46 candidates amongst that 270. Then, my lord, kindly
Paragraph
take
18.
18 is, my lord, kindly take, my lord, 18, I am not reading the whole. The investigation has thus revealed that following 46 candidates were untrained when, at what stage? At the time of TET 2014. These 46 belongs to the first category. This 46 is part of paragraph 17. This 46 is part of paragraph 17.
That is 294.
270. So that is why, my lord, I require to place this. That non
Is that 94 list?
Yes, I'm coming to that. Certainly, my lord. My lord, kindly before I take na Josh sahib age jeta proshno korche seta uttor dao. Now, these 96 candidates your lordship will find at 27. Again, identified. So, my lord, the grain can be separated from the chaff. Unlike SSC, unlike anything. This labeling the entire selection process, dubbing the entire selection process as a scam engineered process is wholly incorrect in the facts of the case. Now, my lord, kindly take paragraph 28. This is very important. When these 96 were recommended, that's also a relevant date. Whether this happened during our time or not.
Para 28.
28.
Yes.
আসবো যশ সাহেব জিজ্ঞেস করছি টাইম কত শুনবে
28, yes.
28, my lord. Kindly take paragraph 28. Investigation has revealed that the aforesaid 96 candidates were also recommended for appointment. Vide recommendation letter what? Dated 4/12/2017. So we get 3 dates. 4th December 2017. We get 3 dates. 2011-2017. 30/11/2017.
30/11 for what?
Yes, kindly take. I take your lordship back to paragraph 15 once again. Kindly take paragraph 15 once again. The resolution of the board. Kindly take page 21.
What are the 3 dates here?
Rather 4 dates. I'm sorry. From at paragraph 15, lordship will find 3 dates. One is 2011-2017. This is, my lord, 9 lines from the top of paragraph 15.
Yes.
Right, my lord has got that. Then, my lord, your lordship will another date. That is, my lord, the note approved by Partho Chatterjee. This is 4th line from the top at page 21. 22/11/2017. My lord has got that. Then in the same, in the next sentence, the next date is 30/11/2017. So for 270 candidates, 3 dates are relevant: 2011, 22/11, 30/11. And for these 96 candidates, my lord, only 4th December 2017 is relevant date. Yes. One more paragraph I would like to.
4th December
2017, as would be evident from paragraph 28. And also kindly take 22. Just one paragraph. My lord, kindly bear with me. Kindly bear with me.
Yes.
The WBBP has informed that no records regarding interview. Whose interview records are not available? No records regarding interview, aptitude test, preparation of merit list panels regarding appointments of candidates under the resolution of the board meetings for awarding 1 mark are available. So that takes us to 2011, 22/11, 30/11. It has also emerged that these 270 candidates were recommended to the respective DPSCs for issuance of appointment letters. Vide memo number so and so dated 4/12/2017 under the signature of Ratna Chakraborty Banerjee, the then secretary of WBBPE. The investigation has revealed that 264 out of 270 candidates were appointed. Thus, it has been established that these 264 candidates were appointed in a grossly irregular manner in pursuance to the criminal conspiracy between Partho Chatterjee and Manik Bhattacharya under the garb of resolution of the board for award of 1 mark to the withheld candidates, which was approved by Partho Chatterjee, the then MIC of Education.
Yes.
Your lordship will find the same date at paragraph 28, which I have already placed. For this 96 or 90, kindly take once. Page 39, paragraph 28.
Paragraph
28, my lord. That is at the end of the list of 96 candidates. So, my lord, we get a now, my lord, the upshot is this. these 264, the appointments of these 264, the services of these 264 candidates is now protected by an order passed by the Honorable Supreme Court. The appointment of these 96 or 94 candidates is also protected by another order of the Supreme Court. And my lord, the applicants and the writ petitioners want us to go who do not even feature in this list. Well, we do not feature. They cannot say that we feature in the list. And everything happened post April 2017. It is not an exercise which was carried out by the board pre-April 2017. And that would be evident from the first, second, third supplementary charge sheet. One more thing, my lord. If your lordship kindly takes the CRM.
All right, Mr. Ojumdar, we got
Yes.
your point.
Now, my lord, I would wish to distinguish the Tripura judgment because questions came up for consideration. Your lordship was putting queries regarding Tripura judgment. If I am correctly understood your lordship, my lord, subject to your lordship's kind consideration. Because my lord, we cannot repeat in a reply.
No, that Miss Arora just now reiterated.
My lord, I will just little more
All right.
detail. My lord, kindly take, my lord, the Tripura judgment which is reported in 2014 SCC online, Tripura 291.
Yes.
Well, even Mr. Bhattacharya says that this has no application. Well, sometimes, my lord, your lordship will find the parties are somewhere added.
On the question of law, cannot
Well, kindly take the judgment. If your lordship kindly takes the judgment from us.
No, you give us the distinguishing.
I am giving the and the paragraphs. And the paragraphs of the, my lord, the reported decision. Well, I have got the SCC online version.
No, you give us the distinguishable points only.
Right. Kumar Jyoti dekhiyechilo na? My lord, first distinguishing feature is that preference was given to at paragraph 4. পুরো জানে।
Give us the points now.
The points is that paragraph 4, your lordship will find that for undergraduate teachers, even Madhyamik pass were allowed to participate, contrary to the NCT guidelines, and even who had appeared in Madhyamik.
Yes.
Then, my lord, paragraph 52 to 66, preference given to older candidates, dependents of the persons who died in harness, dependents of the retired government servants, etc. That was held to be arbitrary because the entire policy was under challenge.
Yes.
One of the most contentious issue, as recorded by the division bench of my lord Guwahati High Court, was that the clause providing for 70% reservation of 70% of the vacancies on the basis of seniority come merit. Para 68-69. And also a reservation on the provision for the persons who are requiring the appointment, economic criteria. My lord, Mr. Bhattacharya appearing for the state made it clear that this is having regard to the minority, the people belonging to the minority. But that was not accepted, whatever. Now, my lord, now, para 85 of the judgment, my lord, the zone-wise selection was sought to be challenged. Then, my lord, in paragraph I, the directions given by High Court, my lord, the directions have been given at paragraph 123 and 124. 123 and 124 are state-specific directions pertaining to the state of Tripura. Then, my lord, in our case, the distinguishing feature in our case that the alleged illegalities crept into the select process post publication of the first set of panel. Post selection illegality at the stage of preparation of additional panels. And Miller, the first process was undertaken, kindly mark, because I will not place the paragraphs anymore.
That is not required, Mr. Onur.
Miller, because the CBI found the first process for that 2011-2017, the process for 2011-2017 was initiated in the month of May 2017. 11th May to 16th May 2017, just the pages, nothing more. Kindly take pages কত ওটা হচ্ছে ওটা এতে চার্জশিটে কত হচ্ছে চার্জশিটে না চার্জশিটে ফার্স্ট চার্জশিটে না ফার্স্ট চার্জশিটে এটা আছে মানে pages 107 108 of the my lord the CRM your lordship will find that. Then my lord now মানে হচ্ছে তোর এই যে 11 থেকে no, Malad, I had given the final fourth
that we have taken note of.
Now, Malad, I am referring to page 106, 107.
Of this.
No, of the initially which was filed on behalf of the applicant.
Yes. 106.
CRM, your lordship was handed up with a copy of the CRM. Page 106, 107, 108. Your lordship will find the relevant date for initiation of this kind of allegedly illegal process took place in the month of May 2017, more particularly from 11th May to 16th May 2017, when we were all appointed. And the final recommendations were made 2011, 2211, 3011, 2017, so far as the 270 candidates is concerned. And 4th December for these 96 candidates. Both 96 candidates as well as 270 candidates.
All right.
So this is there. Now, Millard, I come to a very interesting chapter. One more. Kindly take page 55 of that CRM for once. This is the first impression of the CBI. Malad, kindly take page 55 from the very beginning. Investigation has also revealed. Malad has got that?
Yes.
An email was sent to the undeserving candidates from whom money was collected. From email, do not reply at primetet.in, wherein it was mentioned that their names were included in the present merit list. However, no such candidates' names were included in the valid merit list or the panel of WBTET.
It has been told to us by Mr. Dotto.
Then, Malad, so far as charge sheet is concerned, Malad, we stand, our submission stand concluded. Now, Millard, I take your lordship to a very interesting aspect of the matter, which I want to highlight. Chart Some can, not all, some of them are in service. Some of them are in service. Some of them are in service, but the date, but I am not able to say. Date I will not make. Now, my lord, now kindly take this one.
What is that, Mr.
My lord, this is, my lord, this is, I will demonstrate from your lordship, to your lordship, why the subsequent recruitment process, they say that their argument is very queer in the sense, they say that very well they have been appointed in subsequent recruitment process. That is why they can challenge whatever illegalities have been committed in this recruitment process. They have been employed as a result of the subsequent.
All of them pertain to, do not pertain to 2016.
They pertain to 2016 recruitment process.
We
do not know
which year, 12 or 20.
They are all TET 2014 qualified candidates.
Very good. They have been appointed.
They have been appointed in subsequent recruitment process. They say that we can very well challenge the 2016 recruitment process where illegalities were committed according to them. My lord, kindly now take the writ petition for once. What was the writ petition about?
Writ petition of the
main writ petition.
Those our writ petition.
Yes, my lord, our writ petition. Our writ.
You tell us, it is almost
my lord,
by heart now.
Your lordship, then my lord, I just remind your lordship of paragraph 10, 11, 12 of the writ petition.
Yes.
Where they say that all the subsequent recruitment processes were marred by illegalities.
Yes.
Your lordship remembers that? And now they say that I may have participated in the subsequent.
I am beneficiary of that illegal.
Yes. And this is the chart which will demonstrate that how the things worked out for them. একটা কপি ওদের দিতে
সবগুলো ইলিগালিটি আছে তারপরে এগুলো তো চালুই হবে ইলিগালিটি
My lord will kindly take that because this is what we could gather because despite repeated reminders, my lord, despite I made fervent prayers, but the roll numbers of all the candidates, all the applicants have not been supplied to me. This is on the basis of what I could gather, my office could gather, my juniors could gather. And I'm grateful to each one of them.
All right.
Lordship may kindly take the chart.
Chart not required.
Well, it is necessary because your lordship will find what has happened. Because my lord, we are now, my lord, an argument Mr. Bhattacharya started making his submissions, if I correctly remember, quoting Sir Ashutosh Mukherjee, that truth has to be found out.
Yes.
We are in the search of truth. My lord, my submission to that would be the seekers of truth would also have to take the part of truth, which they have not done so.
Yes. Yes, what you are showing in this?
No. My lord, they are now super sleuths. They don't believe the CBI charge sheet in its entirety. They are super sleuths. They are the super detectives, super investigators. And they want your lordship to convert this, my lord, intra-court appeal proceedings into a kind of, my lord, commission of inquiry. Kindly take, my lord, paragraph, page 1. I will not trouble your lordship with the entirety because this is just for the records. My lord, this your lordship will find. These are all. I've given the details of the names of the candidates and their position and their applicant number in the CAN 3. And also I have, my lord, at the footnote, I have given the litigation history of that recruitment process. As a, my lord, as a kind of ready reckoner.
Now, then out of this 140, how many candidates as per your calculation?
My lord, 140 petitioners. Yes, my lord, kindly take, my lord, page 2.
How many? You must have.
Well, I've got, I'm giving your lordship. 46.
They are not the read petitioners.
না read petitioner আছে read petitioner আছে because আপনি জানেন না
in this internal page
Priyanka Naskar herself is there.
Petitioners in WPA, this petition who were allowed to participate in 2022. How many, if they have participated?
Yes.
Does their challenge fail?
Well, they have participated, their challenge do not, well, they should have, my case before lordship is that
they should have said that.
Not only said that, the matter, the entire issue was pending consideration by Honorable Supreme Court regarding this recruitment process, because all these candidates, including Priyanka Naskar and others, were pursuing DLED course when this recruitment process was initiated. They were yet to complete the DLED course. My lord, by orders passed by this Honorable Court, by the Honorable Single Judge, my lord, they were allowed to participate. Matter was carried to Honorable Supreme Court. The Honorable Supreme Court directed the board to publish a list of the candidates and also issue a notice so that they can participate. From that list, we could gather that these candidates are the common petitioners. That list is a public document, and that notice I have indicated at page 1 of my note.
So 46 of the petitioners out of 140 participated in the subsequent recruitment process and were appointed.
Not yet appointed.
Not yet.
Not yet appointed. One.
Anything now kindly.
Now, my lord, kindly take and admit, and my lord, indisputably 14 candidates from CAN. Apart from, my lord, those who had been appointed. My lord, CAN 3, 14 candidates from CAN. My lord, first table is 14 candidates from CAN, because we could not get the roll numbers. Had we got the roll numbers, perhaps, my lord, we could have found out more.
So this first 14 and 46. That
first 14 is
60.
CAN 3, 46 is the writ petition. To the best of our information, and my lord, this cannot.
Now these 14 have been appointed.
Again, my lord, it is pending consideration. Not Supreme Court. Supreme Court has issued a in contempt proceedings. Supreme Court has directed the board. The board will be able to say that you immediately complete the recruitment process.
I see.
And all their names were included in the list appended to the notice of February 2024. 24th February 2024.
Yes.
Second, we have dealt with in a recruitment process wise, because now B, that is page 4.
Yeah.
Your lordship will find
out of CAN 3, somewhere parties to the writ petition.
One not party to the writ petition regarding recruitment process of 2020, Ali Hossain Mandal. And this Ali Hossain Mandal not only challenged the entire process, challenged his non-conclusion, the matter traveled to Supreme Court and he failed before the Supreme Court. And that judge, that nothing has been disclosed in the CAN.
No, Ali Hossain is not a petitioner before us.
CAN. In the CAN.
In the CAN.
Not the writ petitioner.
So this Ali Hossain has what
participated in 2020 recruitment process.
Achha.
My lord, which is again, my lord, paragraph 10, 11, 12 of the writ petition. And my lord, paragraph 50, now his applicant number 58 in my lord CAN 3. My lord, the matter traveled to Supreme Court. Even the judgment is reported in SCC.
Which matter went to?
My lord, this Ali Hossain's matter regarding 2020 recruitment.
Yes, 2020.
Yes, I'm saying that. My heading says so. My heading says so. And my lord, I believe learned advocate general appearing for the board cited this judgment rendered in Ali Hossain's case. Now, my lord, we come to the C, the third category. This is an additional panel, 5% in terms of Rule 86 and pertaining to, my lord, 2016 recruitment process. Writ petition, my lord, is pending. Disposed of hoyni bodha.
So this Rakesh Mondal petition, they were parties.
Rakesh Mondal himself is here in CAN 3.
Now what your
lordship will find interestingly, in this Rakesh Mondal writ petition, which pertains to, my lord, this additional 5% panel, the agency was directed to use that affidavit, which has been relied on by, my lord, the applicants as well as some other petitioners, writ petitioners or something like that. And your lordship will find these are the applicants in CAN 3 who were also party in the Rakesh Mondal writ. fourth category, that is D, which your lordship will find at page 7.
Dismissed by the Supreme.
Yes. Allusion has been dismissed by the Supreme Court. But 2020, I made it clear, 2020, I have given the recruitment process. Because all the recruitment processes are now relevant, they are challenging TET 2014 as a whole, lock, stock and barrel.
Yes.
Now, kindly come to D. Applicants in CAN number 3, in MAT numbers, this is our MAT, board's MAT, who were party to the writ petition being so and so, SLP, this matter was also went to SLP, so and so, Moutushi Rai versus State of West Bengal. One, Pintu Kumar Guchai, who is applicant number 70 in the CAN. I have given also the history.
Pintu is in Moutushi.
Yes, Pintu is in Moutushi.
Now, what has been the fate of Moutushi?
Moutushi, my lord, Moutushi has been disposed, my lord, the matter went to Supreme Court, and the Supreme Court, by an order, which is again a reported judgment, directed that the learned judge would consider
It.
In terms of the Ali Hossain Mondal judgment.
Oh, now it is pending.
This is
pertaining to. This is also pertaining to 2020.
No. This is 2016.
No. This CAN 3.
CAN 3.
This
Pintu Kumar Gachayat. The MAT number 42, 44, which I am referring to, your lordship has got.
Yes.
This is referable to 2016 recruitment process. That is our recruitment process.
Then what you want to apprise that?
I want to apprise that this gentleman was a party there. The matter even traveled to Supreme Court. Matter has been remanded back. Learned single judge has been directed to consider the matter in the light of Ali Hossain Mondal's case, which is there. It is again a reported judgment. All these facts ought to have been brought to the notice of this court. But this is one, my lord. I tell your lordship, when we were children, we used to read my lord, Uderzo and Goscinny's Asterix and Obelix.
You are still a child, Mr.
I am still a child. Even still I read Asterix and Obelix. And this corruption is like that magic potion.
Yes, thank you, Mr. Yes.
Would your lordship, one minute?
You want to?
I will take 5 minutes.
Already, sir. Yes. Mr. Banerjee, we have heard any other new point? Reply. Finished?
Our chart, whatever chart we submitted, though that chart could not be disputed by any of them. I submitted a colored chart, remember your lordship?
Yes.
That has not been disputed by any of the.
Yes, already.
I'm grateful, Malad.
Mr. Bhattacharya, please wait, let them.
Yes. Why I'm saying, my lord, let us just relax for at least 1.5 minutes. I remember one incident. In one case, Justice Shishir Mukherjee, my lord, Mr. Tarun Chatterjee is appearing against me. I was for the petitioner, I was for the respondent, opposite party. Now, I started my case. Then Justice Chatterjee wanted to say something. Take your seat. My lord has said, Justice Shishir Mukherjee is very, take your seat. Then he is not allowed to open his mouth. Then after 2 days, matter is over, I lost this case. Justice Chatterjee came to my room number 3 from the road. Are you fee pages? Of course, I've got the fees. I cannot take the risk, my lord, at this age.
No, we have extensively heard you.
No, of course. No. My argument
question of risk does not arise.
My argument is very short. I argued, my lord, because I know my limitations.
Yes, what you want to give?
I can prepare a short note, my lord, 3 pages. Can you take it, my lord? That's it. I'll file it.
Reply also no.
No, I've just 3 pages.
No, you give us the points, Mr. Banerjee. That will again.
First thing, my lord, as I've already told you, my lord, my case is quite different from the other. My case is quite different from other cases. I did not enter into the merit for obvious reasons. Goes to the root of this case. Because the law doesn't mean to be mere theoretical abstraction. It is an instrument to do justice. Where I've got the justice? I was not even allowed because I was not included in the party. Kindly appreciate.
Yes.
So that violates Article 21. My lord, these innocent persons, they are neither involved in any incidents, anything. Without hearing them, and everything is gone. So that's why, my lord, if I open this case, naturally, my lord told me, Mr. Manager, we are giving an opportunity. No, my lord, it's a nullity. So we would use the word nullity.
Yes.
Then, so far we are concerned, they failed to show that there is any violation of Article 14. Then, my lord, interview. And so far, interview is concerned, my lord, we are from the Malda district. Nobody was called for. What is the mockery, my lord? I'm got your number? 269. 269. I have
Who appeared for the appellants in 1368 and 1462.
only one.
Huh?
Only one.
Mr. Ashok
1462.
1368 and 1462.
Only 1462. 1462.
This is what you have said, we have noted.
One 462. 1462. The number of the teachers.
You are the coming within 32,000.
Yes, that's true, my lord. All of them are coming.
You are the appointed persons who's appointed.
Yes.
Yes.
And there is no irregularity.
You gave us 1368 and 1462. However, you are not appearing for 1368.
That is my fault. 1462 only. It is my fault. Only one case. 1462. Because my case goes to the root of the case, I have been deprived and I have been punished. And that punishment has been imposed without giving an opportunity hearing. And not even a party. Unless I make a party, my lord, I won't be able to argue my case. That they are totally innocent.
237.
So, my lord, they are not involved. No illegality against them, no illegality. They have not committed any wrong. Why they will be punished?
All right.
As well as.
Thank you, Mr. Ed. Yes.
One. I'll take only 1 minute. A procedural matter. Serial number.
Very difficult. That is why we requested you 1
I'm
minute.
not arguing on merit, my lord.
Please wait. Yes, Mr. Mitra.
My lord, I don't know. I don't like to hear my own voice. I know your lordships do not want to hear my voice, but I don't know why these people, my juniors are
After
asking.
this, how can we stop you?
No, but well, I tell you, lordship, my lord, 3 sentences. My lord, total vacancies was 42,948.
949.
949. And my lord, by reason of notification dated 23rd September 2016, 10% para-teachers are to be. So if we calculate 10% of the para-teachers, it comes to 4,294.
3205 has been filled up. Rest is.
Yes, total number of para-teachers is 2770. So as a matter of course, I walk in. This 10% you cannot stop. And these 10% have not been heard. Now, my lord, the second submission I make is this. There has been no argument has been made against us in so far as we are concerned, excepting, I think, one learned counsel has said, and that is with regard to this fraction.
Yes.
That is the only, if I have understood correctly. Now, my lord, I have got only one submission to make with regard to that by way of reply. If your lordship looks into that notification by way of amendment, it said, my lord, if your lordship take the amending, it says, my lord, that marks out of maximum 5 marks, my lord, this
amendment.
This amendment was, so far as para teachers is concerned, yes, this is, my lord, 23rd September.
ওই যে স্পাইরাল বাইন্ডিং এ ছিল, ওই যে উপরটা দাও, উপরটা
প্রথম বইটা। Your lordship, can it just takes 2 seconds, my lord, for you from
we are taking up that amendment.
Yes.
Mr. বিশ্বাস page, amendment at page.
Amendment at কোন পাতায় রয়েছে?
Amendment is at page. Compilation you told us yesterday.
না আমাদেরটা না, ওই কম্পাইলেশন এটা।
Original
amendment notification of 24th July.
23rd September. 23rd September 2016. Well, really, I draw your lordship's attention to two notifications. One is 2nd March 2016 original, which was amended by the subsequent notification dated 23rd September.
Yes, what are you showing, Mr.
2nd March 2017, your lordship kindly comes to that.
We are on 23rd September, you said.
Yes, no, but your lordship is on 23rd September 2016. This has amended, my lord, the earlier one, 2nd March 2016. To 2nd March 2016, your lordship remembers, item number 7 of table A was only the aptitude test. Notification rule 8, sub rule 3, internal page 5. Sub rule 3 is giving it, your lordship, a table has been given.
Yes.
In this table, my lord, item 7 was aptitude test, 5 numbers. This has been amended in this
rule 8, which
rule 8, sub rule 3, table A.
Yes, table.
There, my lord, the last one, aptitude test.
Yes.
5 numbers. This was amended by saying, my lord, in the 23rd September.
131 of my spider. 131, page 131.
This one?
Yes. 131. Just 131, your lordship will get the data.
Your lordship will kindly, my lord, keep it.
The new rule. That is the rule. This is amended.
Yes. This is the amended one.
Yeah, just one.
And your lordship takes, my lord. Yes. Yes, kindly, my lord, put a sticker in that because that will be very important.
Yes.
My submission is absolutely confined to this, nothing more.
Yes.
Your lordship sees, my lord, in the amended sub rule 3 of the earlier one had been amended to say
2 parts. Teaching experience, aptitude.
Yes, aptitude test, and so far as teaching experience is concerned, it's only for the para teachers.
Right.
So para teachers, the aptitude test was not required.
Yes.
It is only teaching experience. This teaching experience has been also explained. What is it in, my lord, note 6 of that amendment? Your lordship has seen that? There, my lord, the possibility of any manipulation is not there. Teaching experience, if it is over 10 years, it is 5. If it is experience 8 years, 4, like that, my lord. Experience about 6 years, 3, like that. So there is no question of any manipulation. One looks into the number of years one has the teaching experience and puts the mark. Now, criticism has been made, and I am answering that only, that how is it that if teaching experience 5 for 10 years and for 8 years it is 4, then how could that for teaching experience 3.4, 4.8, this can be given? My answer is very simple. I was asking this question to myself. How is it is possible? Possible in this way, perhaps, that if it is, for example, 8 years and 3 months, that amount of discretion has been exercised. He has put this 3, if it is 8 years and 3 months, then 4.3 or 4.1 or 4.2. If it is 8 years and 9 months, it will be 4. That way, my lord, the fraction has come in. Now, your lordship can criticize that. Your lordship can say that no, if it is 8 years or more, it will be 4. It can't be there in fraction. But my respectful submission is this, that this is the way it has been done. And this has been done by, my lord, application of mind. And it is not, my lord, it's a question of only fraction, 0.3, 0.2. If your lordship feels that no, it should not have been done, remove the fractions, make it 4. Even then, my lord, I get selected. So, my lord, I am submitting to your lordship, then from whichever point your lordship look at it insofar as we are concerned, there could not have been.
Your argument is even fraction is removed, you come.
Yeah, I come in. Nobody will, and my lord, I will not, my lord, enter into the domain of anybody else. And my lord, my submission is this, and this is my grievance, that when
you are making the submission because there are excess vacancies.
Yes, yes.
No, how we are to treat your submission as?
No, because
that, if as it is excess vacancy, even if you remove the fraction, I come.
Yes.
You come within the proportion by which it has been filled.
Yes, of course. Because what I am showing to your lordship is this, that if the 10% of the total is 4,294, then any event to 2,770 come in. You remove the fraction, you keep the fraction, whatever you do, we come in. So that being the position, my lord, I am criticizing the trial court judgment by saying that this kind of putting everything in one basket, that was the rotten eggs should not have been put with the good eggs. And this is, my lord, where the learned judge has gone wrong.
How can you find out those rotten eggs?
Yeah, I do not care. I am saying that I am not the rotten egg. If I am not the rotten egg, then I must come in. I do not, if there are rotten eggs, the authorities concerned will sort it out. But for the purpose of getting rid of the rotten eggs, you cannot get rid of the good eggs. This is what I am submitting to your lordship. In Bengali, we call it Muri Murkir Akdar Kote Paro na. If you can't do that, then, my lord, in my very respectful submission, this could not have been done. Para teachers should have been kept completely out of this consideration. And in fact, my lord, no criticism has been made. I had been listening very carefully to the submissions of the learned counsel for the other side. There had been no criticism accepting this fraction. I say remove the fraction. Even then I come in. You cannot touch me. So this is all that I wanted to submit, my lord. I don't want to.
Yes, it's good. Yes, it's good.
But this is all that I want. I don't want to increase your lordship's agony. But, my lord, these are all the submissions that I want to. I'm very grateful.
Yes, what you are saying?
But may I hand up this the mat in which I am appearing, so that, my lord, there is no
Matt,
966. We have not been made parties. We made an application for leave to prefer this appeal, and thereafter I have come into it.
In 1547.
What but 1547 the hour? 966 only.
Appeared in 966.
966. That's the only appeal I am appealing.
ঠিক আছে. Yes,
Lordship.
what you are saying?
With regard to today's item number 36, that is MAT 1974.
Who argued?
I'm one of the applicants.
No, who argued? Did you argue?
Within 32,000.
No, did you argue?
No. I
Okay,
just want to say.
Now you please do not add anything.
I'm not adding. I'm
Then why didn't you argue at that time?
The arguments are over now, Milord. I only want to draw to your lordship's notice that there are some petitioners who doesn't want to proceed with this appeal. They want to withdraw their name.
Out of 182?
Out of 182 appellants in this appeal, Milord, six of them doesn't want to proceed.
It becomes imperative.
I understand, but still, Milord, it is my duty to, because they have given us instruction that they don't want to proceed with this appeal.
We will again delete their name, send it to the department, comment it.
It's not necessary. Your lordship can only record it. I can here and now delete the name, expunge the name.
No. That's over. That
Let it be recorded.
Whichever way the judgment goes, you will not be involved. So what is your problem?
No, Milord, if the judgment goes against us.
What against you?
Milord, I have left.
You are.
I was. I'm not. No, we don't want to proceed because I'm not in service now. I have left.
You are similar to Priyanka.
No, then we have left the service.
You are within those 32.
Yes, we were within those 32. We don't want to proceed with the appeal now.
So very good. If you have gone,
but we have filed an appeal, so our name may be deleted, Milord. That is what we want.
But sir, whichever way it goes, you will not be influenced in any manner. If we uphold also, you will.
The service, then how will you be?
Yes, what is it?
I will be tainted if the judgment goes against the appellants now. I will be tainted as if I have got the service by some mischief. Because I have left the service.
Can you come at any sweet will and say this? 4 months we heard the matter.
Yes.
Not as now you are saying. Now the court, we don't know, it may set aside. I will be tainted. These how?
No, Milord, it's not that, Milord. Just the if the 5 appellants doesn't want to proceed with this, their names can be expunged. That's all what we want, Milord.
Only 6 out of 182.
For in which appeal?
1974.
Did anybody address us on 1974?
No, nobody addressed.
You are appearing for all the appellants there?
Yes. There are 182 appellants.
None of you want to withdraw the entire appeal?
No, only 6.
6 of the appellants.
Matt, how much?
Milord, Matt 1974 of 2023.
ওটা তো অফিসে পাঠালে এখন আর আসবে না।
point that was
my lord,
One line, my lord, from Mr. Sabir Ahmed's petition. Yeah, testing. You people are testing our patience. We first thing we said, you could have told it to Mr. Mojumdar. We could have. Yes.
The fact that people can appear in date in one particular district and thereafter opt for another particular district. That will be appearing from their list himself. Kindly sees.
They are not disputing that, Mr. Lahiri. They are not disputing that.
They have made a representation as if only my lord, the respect of the date will be guiding. That is the representation which was given to them.
Yes, what is your contention? Tell us.
Kindly sees, my lord, the
No, you tell us now.
Yes. Mr. Narayan Mondol, who has been quoted as if he has been, my lord, deprived, is, my lord, from 08 code.
Narayan Mondol is which petitioner?
My lord, he has been quoted by Mr. Sabir.
Which petitioner?
My lord, this is in can 4. In can 4 in MET 580, my lord. Kindly takes up this, my lord, they have given, my lord, of Mr. Sabir Ahmed.
What do you want to say?
Point is that, my lord, they have been, my lord, they have been trying to, my lord, substantiate that the district court will be the determining factor. District court given date will be the determining factor vis-a-vis the appointments too. That was their point. They have shown Purulia district court 17. Now, in their example itself, my lord, they have quoted one person who is in district court 8, that is Nodia. But they have compared them with another district court, which is of district court 9. So therefore, they are also aware of the thing that a person can give state examination from anywhere in the district, but while participating in the recruitment.
What is the page number of that comparison?
65. Huh? 65 of the compilation that has been handed over
by Sabir Ahmed.
Yes, this one. Kindly see this one.
Page 65.
Yes.
Yes. Where you are showing?
Okay. Kindly comes to page 65.
We are in page 65.
Yes. Kindly sees Narayan Mondol, who has, my lord, been shown to appear from 08.
Yes, Narayan Mondol, 08.
Yes, 08.
They have been compared with 09.
09.
Very
09 is 24 Pargana.
Thank you. Yes, Mr.
My basic argument was that this is institutional corruption, started from the initial stage of appointing that company. Yes, Basura and Company. Number the specific point was taken that the rules were to be published by the board according to rules. That's the basic rule. Sub-rule L. Not done, not has been satisfied, nothing has been produced. Well, as per the requirement of the rules, these committees can only be appointed with the prior approval. I have stated, I am just reminding your lordship.
You stated, Mr.
Yes. No approval of the state government was taken. Now, today, Learned Advocate General has produced a bunch of papers, which practically fortifies my submission. The Learned Advocate General has given a chart. There it puts that what action was to be.
That resolution you are showing?
No. The bunch which was produced Learned Advocate General.
Yes, started.
Yes, yes. একটু মনে থাকবে যে এটা প্লেস করেছি।
Now that page 6 of the internal page 6 of the bunch, which will shows what actions are to be taken by the S. Basura and Company, which is a part of the selection procedure.
Yes.
One. And
where it is said, which portion
is? Kindly come to page 6, the item number 2.
Yes.
It is also submitted that after publication of TATE 2014 result on so the confidential processor,
that is Basu,
has been requested to do following jobs. arrangements for online applications for about 125 lakh qualified candidates and collection fees thereof. This is the starting the process of selection. This is post-state. On receiving the online application arrangements made for preparation of district-wise list for scrutiny, verification, viva voce, interview, and aptitude test. Therefore, the entire selection process, my lord, for 2016 was handed over to S. Basurai. This is, my lord, the document produced by Lord Advocate General, which I just point out to your lordship. Now, my lord, then kindly sees about the constitution of selection committee. I am nothing arguing new. I am just showing the documents on that Advocate General.
But kindly give us a chance to clarify
Page,
this one.
page.
My lord, internal page 8.
Yes, page.
Here it appears that one selection committee was proposed. I mean, no document that has been placed to show that the selection committee has ever sat.
Which portion you are saying?
Page 8, agenda number 11.
Yes.
It is proposed
This
that
was the constitution.
yes, but no document has been placed before the court to show that this committee had ever sat.
Yes. Anything else, Mr. Bhattacharya?
And that's all. This I want to point out, and there is no document to show that the government had granted prior approval before appointment of S. Basura and Chaudhary. Well, this is one ground on which the SSC matter Article 14 was invoked and it was set aside. Therefore, this is no question of individual cases. We are challenging the action of the statutory body. The statutory body has to justify. The beneficiaries, in my humble submission, Lord, cannot improve by any means the actions of the statutory.
Actions of this.
That's all. Also, can you take note? Taken Rule 8. This is procedure of selection.
Rule 8.
Not you have taken note.
6. Subject to the approval.
That is rule sub rule 5.
Achha, wait.
Now rule that is sub rule 5 of rule 8. Rule 4. And now, the rule 8 is the procedure of selection. Lordship has seen that. I am not troubling my with that. This procedure, has never been followed.
Rule 7.
Rule 8.
Yes.
Rule 8, this is the procedure for the selection. The selection committee shall make.
Selection committee. Yes.
And Milord, there has been no publication of merit-wise list. The entire thing would have been solved not had they produced the broadsheet of selection committee and the panel. In absence thereof, Milord, I think no argument can stand to justify these appointments. And the affidavit filed by the S. Basurai company, which I have placed, that has also not been controverted by any affidavit by anybody.
All right. Thank you, Mr. Bhatt.
Yes,
Ashok,
Mr.
the learned
One
advocate,
may I give
respective
one
parties
clarification?
have
Before your
concluded their argument. We cannot allow at this stage.
They
We
were
have
appointed
reserved
by order.
judgment.
Well, I understand, my lord.
Sir,
But they were,
we cannot.
I understand, my lord. Kindly.
We are sorry, but we cannot do that.
These persons have been appointed by orders of this honorable court, my lord. That is the whole difficulty. That is the whole grievance of this petitioners, my lord.
Who are
My
appointed?
lord, these persons who are trying to ventilate their grievances before your lordship by way of this application as an inventor, my lord, they were appointed by orders of this honorable court. 27 of them in the district of Uttar Dinajpur. That is the reason we have taken up this application to ventilate this point.
You are within the 32,000.
Yes.
Yes.
And unfortunately, I have been placed in 32,000 category, even if I have been, I am a trained candidate and appointed by orders of this court.
The specificity is not important here.
Well, we have assailed this in a writ petition, but well, any orders could. But we have taken out an application already. It's there.
High Court had never
Yes, we have
passed an
taken out
order
an
of
application.
appointment.
Can one court too?
When, sir? When you have taken?
Well, very recently. It is not in the list. That is
How can I do? Sorry, miss.
It is
Yes, chalo.
There are two cans, my lord, can 13 and can 126.
Uh-huh.
My lord, there are two cans, my lord, can 13 and can 126. Kindly, my lord, dispose of this two cans, my lord. They are similarly situated with PRIYANKA NASKAR.
We will be delivering the final judgment.
Yes.
That will be binding upon all the interveners, all the parties added, read petitioners, respondents, everything. Naturally, this
Can you record, my lord, can 13 and can 126, my lord.
what we will record, madam.
Can you dispose of
That
this?
will be there in the cost title.
So this, my lord, allow this
That is an addition of party application.
Yes, my lord.
We are disposing of the entire matter. Your application will no longer remain. Chalo, দেখো। Objection if this is taken on record.
Let everything be taken on record. In Muhammad submission, that to avoid that in future
তাহলে
বিকাশ থেকে তো এটা বলতেই হবে এভরিথিং, বিকাশ কিছু নেই।
মিস্টার
ওকে তুমি মিসগাইড করো না না স্যার একদমই একদমই
no. The read petitioners there were the applicants here.
Yes.
You have been granted appointment when?
My lord, in the after expiry of this panel up to 20.
Erom lekho, they have been applicants have been granted appointment on the basis of an order dated 30th November 2017.
Page 64 is the first appointment letter.
30th November 2017, passed in WP 15864 WO 2017. Mr. Bhattacharya was right. He said that this is not an order of appointment.
Yes, my lord.
This is a consideration. That is what he is
And
pointing.
my lord, and kindly seize the subsequent pages, my lord.
No. We have recorded your submission. Find out if we have recorded your submission. You for the applicants in those matters which that application is treated as on days list. When did you file? Today.
No, not today.
What is the date?
Yesterday, day before yesterday.
Day before yesterday has a date, na sir? Give us the date. You must have filed it. You must have affirmed it today.
No, no, that.
ওটা যদি আনাতে পারবে application টা।
আমার নামটা হচ্ছে 142.
Registered as today. Online showing, my lord, it is registered today.
আনাতে পারবে?
Item number
52 page.
Mr. Joint Mitra has big submissions. I just adopt Mr. Mitra's reply. Item number 42 and item number 9. Part of item number 9 is parity. I just indicate this that I have adopted. That's nothing. Item number 42 today para teachers, all of them. Item number 9.
Just
sorry.
You are in which? You are in application number.
Application number.
You are appearing for whom?
For the appellants in item number 42 today, for all the para teachers. All the appellants in item number 42 are para teachers.
What is the number of the appeal?
MAT 13, I'm sorry, 913 of 2023. And in MAT number, item number 9, MAT 1368 of 2023, some are para teachers, some are non-para.
Are you appearing for
Yes.
them?
These are my two matters.
The other appeal?
MAT 1368 of 2023. Some of them are para teachers, some are not.
Anybody else? Anybody wants to make any line or add?
Not one clarification which Mr. Lahiri has argued. My learned friend has said that I have taken the number, the district code.
Other district.
But the first page 60, I said there are 427%, 486% who have got lower marks than me, and I could find 17 name of the person who have been appointed in Purulia district itself.
Yes, what is your argument?
My argument is that in each district, despite they have
how many persons appointed according
17 in Purulia.
Total number of persons?
27. 486. Sorry. 486. I've given it page 60.
486 appointed.
And I could only find
all of them has secured less marks than the candidates who have been appointed.
But yes.
Who have not been
No,
who have
less marks.
Sorry.
And I could find name of 17% who is working in the same district. Now, my lord, everybody has produced
Don't give any further copy. We are you are appearing for which can did you appear?
Can 4, my lord.
Can 4 and in the list which you have given, you have stated 486 candidates.
Page 60.
Page
60.
Yes, page 60. What you are saying?
So
You
far,
don't, what is your statement? 486 persons grievances that you have not been given appointment.
But this
Though you have secured more marks than the persons appointed.
My
This is your contention.
And Lord, I could find that
So the medium is important.
Lord, yes, that is what I'm saying. Lord, out of Lord, since my learned friend has raised that medium and they have opted for a different district, I could find, for the time being, I could find 17% who has got lesser marks in Purulia but have been appointed. I've got the list of those parties.
Then 417.
I say that
I can deal with that.
Now.
Fine now.
Let them. No, all cannot migrate, Lord. All cannot migrate.
You are for the district of Purulia.
No.
You applied in Purulia.
Yes. One candidate in Purulia, but there are many candidates from different districts. But in all districts, there are, I have given that comparison chart where less meritorious.
Securing less marks than you have been appointed.
That's my contention was.
One more submission, my lord. Only, my lord, before rising, my lord. Before lordships of desire, my lord. Once, in addition to Mr. Ahmed's submission, my lord, I one candidate where the same code, the 09, that particular code for district, it is not that the different code or different district they are coming. I got this lady.
You are opposing that statement.
Statement.
Don't give any further
statement. In support of the statement.
Opposing the statement made by them. Yes. Thank you.
In my case, my lord, I have preferred writ petition. In the writ petition, they have filed a report disclosing our score and the cutoff, and it shows that we have secured more marks than the cutoff score.
All right.
But I have two applications, but here the applicants could not participate in the interview process because their result was published at the belated stage pursuant to the order of the Supreme Court. Even if my interview score is not added, even then I will be qualified. Without the interview marks, I will be qualified. Yes, writ petition is pending.
Your writ petition is pending. Sure.
Grateful.